Tes.
Oke. Cek. Udah.
Indonesia is the most beautiful land in the universe. The land where we were born. The nation where we grew up. So many colors that live together in peace. With a million timeless treasures. With an abundance of natural wealth. Indonesia is not just wonderful. Indonesia is a wonderland.
Nanti aku naik karena itu orang semua. Cek, cek.
Cek. Assalamualaikum warahmatullahi wabarakatuh. Waalaikumsalam
Waalaikumsalam
warahmatullahi
warahmatullahi wabarakatuh.
wabarakatuh. Good morning, ladies and gentlemen. Welcome to the 5th MICoLLS International Conference on Law, Legal Studies, and Social Science, or MICoLLS 2025.
Selamat pagi Bapak dan Ibu yang kami hormati, para pembicara, tamu undangan, serta seluruh peserta konferensi, baik yang hadir secara langsung di Universitas MICoLLS maupun yang bergabung secara daring melalui Zoom meeting.
Please take a moment to make sure your devices are connected properly. For online participants, kindly rename your Zoom ID with your full name and institution.
Selamat datang di The 5th MICoLLS International Conference on Law, Legal Studies, and Social Science atau MICoLLS 2025 dengan tema
Legal pluralism and local wisdom,
Harmonizing Customary, Religious, and State Law in a Global Context.
Allow me to extend our warmest greetings and highest respect to our honorable guest, the Honorable Director of Universitas MICoLLS, our honored the Vice Rectors of Universitas MICoLLS, our honored the Dean of Faculty of Law, along with all Vice Deans and the Academic Board. Our honor, the academic community of MICoLLS University, and our distinguished keynote speakers joining us from Indonesia and abroad. There's Associate Professor Dr. Muhammad Helmi MD Said from UKM Malaysia, Professor Anthony Adiala from Western Cape University, South Africa, Professor Jenny Newbing from Van Hollen Institute for Law, Governance, and Society of Leiden University, Professor Yuwis Nurlailawati, MA PhD from UIN Sunan Kalijaga, Yogyakarta. Welcome everyone. It is truly honor to have you all here today.
Dengan penuh rasa hormat, izinkan kami menyampaikan ucapan penghormatan kepada para tamu kehormatan. Yang terhormat, Rektor Universitas MICoLLS. Yang kami hormati, para wakil rektor. Yang kami hormati, Dekan Fakultas Hukum beserta para wakil dekan dan jajaran pimpinan. Yang kami hormati, seluruh sivitas akademika Universitas MICoLLS, serta para keynote speaker yang hadir dari berbagai negara, yaitu Asok Profesor Dr. Muhammad Helmi MD Said dari UKM Malaysia, Profesor Anthony Adiala dari Western Cape University, South Africa, Profesor Jenny Ubing dari Van Eleven, Institute for Law, Conference and Society of Leiden University, and last, Profesor Yus Nurlelawati MA PhD dari UIN Sunan Kalijaga, Yogyakarta. Kami ucapkan selamat datang dan terima kasih atas kehadiran Bapak dan Ibu sekalian. Suatu kehormatan bagi kami dapat menyambut Anda dalam acara ini.
To begin this meaningful event with blessings, let us listen to the recitation of the Holy Quran, which will be delivered by Zul Hairan Ridan. Please welcome him warmly.
Disampaikan oleh Saudara Zulkhairaridan. Kepada Saudara Zulkhairaridan kami persilahkan.
Assalamualaikum warahmatullahi wabarakatuh. A'udzu billahi minasy syaithanir rajim. Bismillahirrahmanirrahim. يا أيها الذين آمنوا إذا قيل لكم تفسحوا في المجالس إذا قيل لكم تفسحوا في المجالس فافسحوا يفسح الله لكم وإذا قيل انشزوا فانشزوا يرفع الله الذين آمنوا منكم والذين أوتوا العلم درجات والله بما تعملون خبير يا أيها الذين آمنوا إذا ناجيتم الرسول إذا ناجيتم الرسول فقدموا بين يدي نجواكم صدقة ذلكم خير لكم وأطهر فإن لم تجدوا فإن الله غفور رحيم فإن لم تجدوا فإن الله غفور رحيم صدق الله العظيم أستغفر الله العظيم الذي لا إله إلا هو الحي القيوم وأتوب إليه. نعوذ بالله من الشيطان الرجيم. بسم الله الرحمن
Recording in
الرحيم.
progress.
الحمد لله رب العالمين. الصلاة والسلام على أشرف الأنبياء والمرسلين وعلى آله وصحبه أجمعين. اللهم إنا نسألك سلامة في ديننا وعافية في الجسادنا وزيادة في علمنا وبركة في رزقنا وتوبة قبل الموت ورحمة عند الموت ومغفرة بعد الموت. اللهم هون علينا في سكرات الموت والنجاة من النار والعفو عند الحساب. ربنا لا تزغ قلوبنا بعد إذ هديتنا وهب لنا من لدنك رحمة إنك أنت الوهاب. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا
Recording in progress.
Bumo Acehyo Kenembah Raja Sigap membela bangsa Mulia Nanggro Mulia Dung Syuhada Metuah Bijeh Aceh mulia Ya Tuhanku, rahmat bersampo negeri Aceh yang mulia. Rahmat melimpah, metuah aso, areh kegamo bersejahtera. Mesyuhur makmuran megah Sabita jaga Aceh mulia Bekatkan Aceh melimpah bago Bermesaho mesyedara Bersapa bersawonyo menemat syariat Islam ke hukum bangsa Ya Tuhanku, rahmat bersampo negeri Aceh yang mulia Rahmat melimpah metuah aso areh kegamo bersejahtera Aceh mesyuhur makmuran megah Sabita jaga Aceh mulia Aceh mesyuhur makmuran megah Sabita jaga Aceh mulia
Thank you, Fernanda Zerinda Putri. You may now be seated.
Terima kasih kepada Fernanda Zerinda Putri. Hadirin dipersilakan untuk duduk kembali.
Now, ladies and gentlemen, let us hear the welcoming remarks from the chairperson of the organizing committee, our Madam Chair, Mrs. Laila M. Rashid, SHM Home. Please welcome Ms. Laila.
Hadirin yang berbahagia, acara selanjutnya, marilah kita dengarkan bersama-sama kata sambutan dari Ketua Panitia Penyelenggara, Ibu Laila M. Rashid SHM Home. Kepada Ibu Laila, kami persilakan.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahirabbil alamin. Hadana lihaza wa ma kunna linahtadiya laula an hadanallah. Asyhadu an la ilaha illallah wa asyhadu anna Muhammadan abduhu wa rasuluhu. Rabbi shrah li sadri wa yassir li amri wahlul 'uqdatam min lisani yafqahu qawli. First of all, I would like to extend my warmest greeting to the Rector Universitas MICoLLS or his representative, our distinguished guests, respected keynote speakers who later join us online, all the presenters, participants, lecturers of Universitas MICoLLS, to the 5th MICoLLS International Conference on Law, Legal Studies, and Social Science. This conference already it is the 5th years. This conference organized by the Faculty of Law, Universitas MICoLLS. Today we have a theme, Legal Pluralism and Local Wisdom, Harmonizing Customary, Religious, and State Law in a Global Context. This year's MICoLLS has brought together a remarkable gathering of scholars, practitioners, and students from various universities across Indonesia and abroad. We are proud to announce that this conference is joined by more than 100 participants, including over 86 paper presenters, who will share their research and insights on a wide range of issues, from customary and Islamic law to human rights, gender equality, governance, and environmental justice. We are deeply honored to host 4 distinguished keynote speakers who are leading scholars in the fields of legal pluralism and social science. For the first keynote speaker, we will have Professor Ais Nurlailawati from the UN Sunan Kalijaga, UIN Sunan Kalijaga, Yogyakarta. For the second speakers, we are very proud to have Dr. Muhammad Helmi MD Said from the UKM, Malaysia. And later, after afternoon break, we will have Professor Janine Ubing from Van Vollenhoven Institute, the Netherlands. And the last, we will have Prof. Anthony Diala from Western Cape University, South Africa. All of them will bring and share their knowledge for all of us here. Their presence reflect the strong academic collaboration and intellectual exchange that this conference seeks to promote. This conference promotes bringing local wisdom and global perspective. On behalf of the organizing committee, I would like to express my deepest gratitude for Universitas MICoLLS for its continuous support, all the keynote speakers for sharing their time and expertise, all presenters for contributing their valuable research, and all participants here together, especially our students, for their active engagement and enthusiasms. I would like also to thank the organizing team composed of dedicated lecturers and students who have worked tirelessly to prepare every detail of this event, from planning, coordination, and logistic to technical arrangement for both on-site and online session. Later, for today's 2 days conference, we will have 2 days conference today and tomorrow. Because it's more than just a conference, I hope it is a platform for dialogue, collaboration, and knowledge sharing across discipline and cultures. We hope that this year conference will inspire new idea, meaningful partnership, and stronger academic networks for the advancement of law and social science. Thank you once again for your participation and support. I wish everyone a productive and enlightening conference ahead. Thank you very much. Have a nice day. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Ms. Laila, for your warm remarks and dedication in leading the organizing team of MICoLLS 2025.
Terima kasih Bu Laila atas sambutannya yang luar biasa, hangat dan penuh semangat.
Next, ladies and gentlemen, let us listen together. Now we are pleased to invite the Dean of the Faculty of Law, Mr. Dr. Faisal SAG SHM Hum, to deliver his welcoming speech. Please welcome Dr. Faisal.
Acara selanjutnya, marilah kita dengarkan sambutan dari Dekan Fakultas Hukum, Bapak Dr. Faisal SAG SHM Hum. Kepada Bapak kami persilahkan.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Distinguished Rector of Universitas MICoLLS, respected keynote and invited speaker, honorable guests and dear participant. Welcome to the 5th MICoLLS International Conference on Law, Legal Studies and Social Science 2025. On behalf of the Faculty of Law, Universitas MICoLLS, I am truly honored and delighted to welcome all of you to this distinguished academic forum. First and foremost, let us express our deepest gratitude to Allah Subhanahu wa Ta'ala for His blessing and mercy that allow us to gather here today in the spirit of collaboration and academic excellence. This year's MICoLLS carries a very meaningful term, legal pluralism and local wisdom, harmonizing customary, religious, and state law in global context. This term reflects the legal reality of Indonesia, especially in Aceh, where customary, religious, and state law coexist and interact dynamically. Through the spirit of legal pluralism and local wisdom, we are reminded that building a just and sustainable legal system must be rooted in local value and will responding to global challenges. This conference serves as bridge between traditional and modernity, between local value and universal norm. MICoLLS is not merely an academic event, but also a platform for strengthening international academic network and encouraging inclusive legal discourse. I would like to extend my deepest appreciation and to organizing committee, our speaker, and all participants for their dedication and hard work in making this event possible. Your presence and participation truly reflect our shared academic spirit and commitment to advancing the study of law and social science. Finally, I hope this conference will bring meaningful insights in inspired new idea, foster international collaboration, and further strengthening Universitas Maluku Saleh recognition on the global stage. I wish you all productive and inspiration conference. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Check. Thank you, our Dean Faculty of Law, for your inspiring words and encouragement so that our MICoLLS 2025 is officially open. And ladies and gentlemen, that concludes our opening ceremony.
Terima kasih kami ucapkan kepada Bapak Dekan sekaligus pembukaan acara MICoLLS 2025 kita pada hari ini.
We would like to express our sincere gratitude to all honorable guests and speakers for gracing this opening with your presence. Please take a short coffee break and we will continue at 10:30 a.m. sharp with the keynote speaker session which will be led by our moderator, Mrs. Fitri Mahfira SHMH.
Hadirin yang kami hormati, demikianlah rangkaian acara opening ceremony telah selesai kita laksanakan. Kami ucapkan terima kasih kepada seluruh tamu undangan, pembicara, dan peserta yang telah berpartisipasi dalam sesi pembukaan ini. Selanjutnya, kita akan beristirahat sejenak untuk coffee break, dan acara akan dilanjutkan kembali pada pukul 10.30 waktu Indonesia Barat, dengan sesi keynote speaker yang akan dipandu oleh moderator hebat kita, yaitu Ibu Fitri Malvira SHMH. Kami, selaku Master of Ceremony, saya, Nanda Setia Saputra, dan rekan saya,
Najwa Salsabila.
pamit undur diri. Wassalamualaikum
warahmatullahi wabarakatuh.
Terima kasih dan sampai jumpa pada sesi berikutnya.
Yuk. Ini berapa? Audionya ada. Di sini masuk. Ke video masuk, audionya enggak. Ini kan nggak connect audio. Itu bisa ngedit sih. Nggak ada yang itu suaranya. Coba Bapak stop share dulu. Jadi udah saya. Suaranya itu connect itu saya. Iya. Coba Bapak. Dulu.
Assalamualaikum, Prof. Please. Prof.
Salam, tadi kurang terdengar. Ya,
Oh iya ya.
ya.
Maaf.
Salam, selamat wabarakatuh. Ya, terima kasih.
Untuk screen PPT-nya kami yang share atau Prof?
Kalau diperkenankan saya yang share. Ya,
Oh, ya. Baik, Prof.
ya.
Apakah Prof sudah ready untuk kita mulai?
Ya, ya.
Oke.
Saya
Baik,
sudah
Prof.
siap. Ya,
Ya, oke. Terima kasih, Prof.
Ainun. Mbak Laila. Bu Ainun. Ya,
Kita
teman-teman.
mulai, Prof ya.
Ya, baik.
Bismillahirrahmanirrahim. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillahi Rabbil Alamin. Wassalatu wassalamu ala ashrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajma'in. All praise be to Allah, the most gracious, the most merciful. Salawat and peace be upon the Prophet Muhammad sallallahu alaihi wasallam, his family and his companions. Good morning, distinguished guests, esteemed scholars, keynote speakers, and all participants from around the world. It is a great pleasure and honor to welcome you all to the fifth MICoLLS 2025 under the theme Legal Pluralism and Local Wisdom, Harmonizing Customary, Religious, and State Law in a Global Context. Allow me also to express my highest respect and appreciation to the Rector of Universitas MICoLLS and the Vice Rectors and the Dean of the Faculty of Law and all distinguished university leaders and the entire organizing committee who have worked tirelessly to make this important academic gathering possible. My name is Fitri Makfirah, an assistant professor at Faculty of Law, Universitas MICoLLS. And I'm delighted to serve as your moderator for this session. Today, we will explore how different legal systems, customary, religious, and state law can coexist and support justice in multicultural societies. But before we begin, I would like to warmly invite everyone to take a deep breath and enjoy the moment of learning together, because conferences are not only about papers and theories, but also about building connection. So it may be the beginning of a new academic friendship here. This year, we are honored to host four distinguished keynote speakers representing Indonesia, Malaysia, Netherlands, and South Africa. Scholar who works has profoundly shaped global discussion on legal pluralism. They bring to us diverse and complementary perspective from gender and religious courts, comparative Sharia and civil frameworks, global local governance of customary system, to the harmonization of plural legal order in the global south. Together, their insight will guide us in the understanding how life is not only in statute, but in culture, identity, and social change. Ladies and gentlemen, it is my honor to introduce our first speaker, Prof. Ais Nur Lelawati, MA PhD from UIN Sunan Kalijaga, Yogyakarta. Prof. Ais is a distinguished scholar in Islamic family law, gender studies, and religious court practice. Her academic work has significantly shaped the understanding of women's rights, legal reform, and the evolving dynamic of Islamic jurisprudence in Indonesia. She has authored numerous influential studies, including work on joint property and justice for Muslim women, and also exploring legal reform, judicial approach, and advocacy efforts. Last but not least, she also concerned on the contemporary issues such as Muslim women dress in South Asia and highlighting the complex interplay between Islamic law, fashion, and national identity. Today, she will present her paper titled about gender and religion, the dynamic of actual practice of family law at the religious court in Indonesia. We are truly privileged to have her with us. Maybe after her presentation, we will continue to Q&A session. But first, let us warmly welcome Prof. Ais Nurlailawati to present your paper around 30 minutes, and then we continue 10 minutes to Q&A session. Please welcome Prof. The time is yours, Prof. Nurlailawati.
Thank you very much for the opportunity given to me. First of all, I would like to thank the committee for organizing this conference. And of course, I would like also to thank the committee for engaging me in this great conference. Assalamualaikum warahmatullahi wabarakatuh. I'm very excited and honored to be one of the presenters of this conference. And this is a very I think significant event of conference which involved a number of international presenters. I was contacted by Ibu Laila Rashid to serve as one of the presenters in this international conference. So I'm very pleased to accept this invitation. I would also like to thank the rector and all the leaders of the MICoLLS University at Aceh for organizing this conference. I'm very honored to be engaged in this great event. I'm going to present about actual practices of family law in Islamic court in Indonesia, and I would like to refer to the issues of gender and religion. As has been already mentioned by the chairwoman, that I'm going to present something related to the family law, and here it is the title of my presentation, and I have already prepared with some slides to guide us to discuss well and to understand what I am going to discuss about the issue of gender and religion in the relation to the actual practices of family law in Islamic court in Indonesia. As we have known, that there has been recent legal phenomenon in Indonesia regarding familial issue, which has brought to the idea of conservatism in family law. It is, for example, demonstrated by the practices of early or underage marriage and arbitrary polygamous marriage by a number of Muslim society or particularly celebrity preachers. I'm not mentioning the name of the preacher that, for example, have conducted arbitrary polygamous marriage, but I would like to say that it is interesting to see why is it very difficult for us to modernize such legal practices. Even though that the state actually has made a number of legal reforms. So we have, for example, seen the law of marriage 1974 on the law of marriage, which has introduced a number of legal reforms. And the legal reforms that have been introduced in the law of marriage 1974 have then been adopted or accommodated into the presidential instruction in 1991 through the Compilasi Hukum Islam. We have also actually issued a number of relevant regulations to manage or to modernize the issue of gender and religion. We have, for example, the law on child protection, law on penghapusan kekerasan dalam rumah tangga, and we have also actually a number of norms that have been issued by constitutional courts from judicial review regarding women and regarding children and regarding the issue of religion. And we have also actually amended law number 1 1974 through number 16 2009. So with these legal reforms that have been introduced in a number of regulations in Indonesia, it is interesting for us to see why is it quite difficult or hard for us to modernize such legal practices of family issue in Indonesia regarding particularly early age marriage and arbitrary polygamous marriage, and also next I would also to talk about custody. So this is the background of my presentation, and the presentation itself would be divided into 4 sections. The first is introduction, which I am now doing it, and the second is the discussion on legal reforms. I would like to refer to a number of norms on issues of gender and religion. And then I'm moving to the issue of legal practices. I went to the discussion of legal practices. And for this, I would like to refer to the issues of custody, divorce by Rida, and polygamy. And I have some time, then I would also like to discuss about the underage marriage. Then I would conclude my presentation at the end. And now I'm starting with the first part of my presentation. Actually, the second part, because I have already done the first one, which is introduction. I'm going to discuss about the legal reforms in Indonesia through the Compilasi Hukum Islam and Law of Marriage number 1, 1974. And I would like to refer to the issue of religion. So if I see the legal reforms that have been made by the state through the Compilasi Hukum Islam, I found that the legal reforms that have been introduced have to some extent departed from the fiqh or from the classic legal opinion. We could see this from the regulation on custody, for an example. We could see in Article 105 of Compilasi Hukum Islam, which administers that in the event of divorce, the custody of the children of 12 under age of 12 would go to the mother. And after the children attain the age of 12, then they would choose which parents they would go with. So there is no qualification of religion here in Article 105. Tidak ada ketentuan tentang agama apa yang harus dipilih, dan tidak ada ketentuan kesamaan agama. So it means that the Compilasi Hukum Islam has departed from the classical legal text, because if we refer to the classical legal opinion, then the similarity of religion would be put as the requirement for one to be custodian, for one to be haldin or haldinah, untuk menjadi seorang pengasuh. So I see that the Compilasi Hukum Islam has tried to move away from the classical legal opinions, and this is very much relevant with the contemporary issue in Indonesia. And then the second, I would like also to mention about pasah to divorce on or in the event of rida. If we refer to classical legal opinion, rida could dissolve the marriage automatically through pasah. But the Compilasi Hukum Islam has not referred to the fiqh classical legal opinion, because we refer to Article 116, for example, of the Compilasi Hukum Islam, we could find that rida could become a ground for divorce. So it is not the ground for pasah. So it means that it is the right of the spouses, hak para pasangan, to decide whether or not after one of them committed rida to continue the marriage or to dissolve the marriage. So it is also, I think, one of the examples of how kompilasi hukum Islam has departed quite far away from the classical legal opinion, because the rida does no longer constitute as the ground for fasah, but it is a ground for divorce. And it is also more interesting that in the article, it is also stated that not all the rida could dissolve the marriage and could be brought for one to be the ground for divorce, but it is only the rida that results in disharmony. So it is very clear for us that actually kompilasi hukum Islam has made reforms and has already departed from the classical legal opinion. And in terms of gender, we could also see the legal reforms that has been introduced by Kompilasi Hukum Islam and Undang-Undang Number 1, 1974. We could find that in terms of legal reforms, we actually still sometimes refer to the fikih text, but with modification and state intervention in the regulation of the Kompilasi Hukum Islam. We could refer to the issues of polygamy and to the issues of age of marriage. We could see that polygamy in Indonesia is allowed, remains to be allowed. But we could see that there has been a number of detailed regulations for one to be able to enter into polygamous marriage. Although maybe if we compare our legal reforms to the other reforms that have been made by a number of Muslim countries, I think we could place our legal reforms in the second layers of the progressive legal reforms, if I may say so. But I mean, we have also made some kind of legal reforms in terms of polygamy and age of marriage, particularly in the context of age of marriage. We could see in 2019, for example, we have put the minimum age of marriage for men and for women in equal position, which is 19 for men and 19 for women, which was before actually different, because we know that the minimum age for women is 16 and the minimum age for men is 19. But now we have equal minimum age of marriage for both. And in terms of gender in legal reforms, you could see also that we have integrated local values in Indonesia. This could be seen, for example, in the issues or in the regulation on joint property. So we could see that the Kompilasi Hukum Islam administers that the property gained within marriage is to be considered a joint property. So in the event of divorce or in the event of death of one spouse, then the property that was gained in marriage should be divided equally. So I think by integrating local values into the Kompilasi Hukum Islam, we could see also that legal reform have been made in the context of gender equality. We could also see in the article on the administration of custody, we state that age of children in Indonesia does not matter. Because if we refer to the classical legal opinion, there has been like differences of gender of the children. Number of Muslim legal scholars in classical legal texts stated that the age of children influence when the female children or daughter could go with the mother or could stay with the mother, and when they could go with the father, because of the gender roles that have been maintained according to classical legal opinion. And this is quite different from what we have in Indonesia through the Kompilasi Hukum Islam. So this is the, I think, the discussion of the legal norms, which I see reformed in Indonesia in terms of gender and religion. There are a number of legal reforms that actually that could be discussed in the issues of gender and religion, but because of the limited time, so I'm not going to discuss more than that I have already discussed. Now I'm moving to the third part of my presentation, which is the actual practices and the Islamic court in Indonesia. And I would like, as I have already mentioned, refer to the issues of religion and gender. And for this, I would discuss with you three issues of family law, the issues of rida and divorce or divorce by rida, and the issue of custody, and then the issue of polygamy. So I hope that I could still discuss this in a good manner, because then maybe I would be disrupted by the moderator, because my time, for example, has ended. So please remind me of the time. So because I could not stop if I'm not reminded of the lacking time. So I'm going to discuss with you about the divorce, practice of divorce, and I would like to relate this practice of divorce to the religious conversion, because I'm talking about the issue of religion. I would like to please mention that in the colonial era, religious conversion became a huge ground for divorce. And I refer to the book written by Piper. Piper said in his book that it was very hard for wives to get divorced before 1974. As I have already mentioned, that before 1974, we were not provided with the substantial law in Indonesia. So we had to, at that time, refer to the classical legal opinion. And we know that divorce belongs to men or to the husband. So wife could not divorce their husbands. So when they wanted to get divorced, they should ask their husband to divorce them, and they should pay compensation in what term. So before 1974, it was also regulated that the husband could still declare their unilateral divorce. So I divorce you, that would occur. And they needed only to go to the kantor urusan agama before 1974. So in the kantor urusan agama, they would register their unilateral divorce that had been already declared outside the court. But wife had to go to the Islamic court, and it was very difficult for the wife to get divorced from their husbands. So it was interesting, according to Piper in his book, that many wives admitted to having committed apostasy for divorce, because they knew exactly that, as I have already mentioned, that apostasy or rida would constitute the ground for pasah. So they came to the Islamic court and they admitted that they had committed apostasy, and they did this to gain divorce from the Islamic court, and it's untuk mempermudah permohonan divorce mereka. It was very interesting that at that time they succeeded. I mean, the women succeeded in persuading the Islamic court judges to award them divorce, because they had already committed apostasy, although they actually did not commit apostasy. So mereka play around with the apostasy. Jadi mereka bermain-main. It was interesting, if I may mention, that Bupati at the time in Demak, so I'm talking about the Demak area, issued a circular letter, mengeluarkan surat edaran that the women should not play with the kata-kata rida. Jadi tidak boleh bermain-main dengan rida. So what I wanted to say is that apostasy became a huge ground for divorce in the colonial area, because they mostly refer to the classical legal opinion. But we know that in 1974, through the Law of Marriage 1974, and through Compilasi Hukum Islam in 1991, we put apostasy or rida as not the ground for pasah, but it was put as the ground for divorce. So it would be up to the spouse whether or not they would continue their marriage after one of the spouse committed apostasy, or they would dissolve the marriage after one of them committed apostasy. But it was interesting when the couple or the spouses came to the court to ask for divorce under the ground of apostasy, judge mostly ignore the clause of disharmony, because as I have already mentioned, that it is not all the apostasy that would be taken as the ground for divorce. It is only the apostasy that results in disharmony. But the clause of the disharmony was often ignored by most of the judges. So the judges often approved the petition for divorce under the ground of apostasy. So I would like to state that different of religion after the compilation hukum Islam even is considered to be disharmony within the marriage itself. So the court judges, Islamic court judges said, if they had already have been in different religion, they actually have created disharmony. So different faith or difference of religion or difference of faith is considered to be disharmony itself. So the judges were not required, tidak diperlukan untuk to prove, untuk membuktikan whether or not there is disharmony in the event of apostasy in their marriage. So it's very interesting, I think, if we refer to the issue of religious conversion, and it is very much related also to the principle or to the concept of religious protection in its relation to religious freedom. So I would say that in one side that the government has attempted to provide space for the spouse to decide their own marital fate, untuk memutuskan nasib kehidupan perkawin mereka. But in another side that we still have some problem in the practice. I have a number of examples of how apostasy could be automatically taken by the Islamic court judges as the ground for divorce. I refer to 2008 and 2018, but I would like to directly refer to the case 2 at Central Java in 2018. A husband came to the Islamic court to petition for divorce, and he accused the wife of having cheated him, telah berselingkuh. But it was quite long time for them to proceed the divorce. So it was interesting that the husband then came again and stated that the wife had already committed apostasy. And it was interesting, actually. The apostasy itself was committed 10 years ago. So it was not the apostasy itself that brought them to come to Islamic court. It was the perselisihan terus-menerus because of the cheating of the wife to the husband. But it was interesting because they stressed the readout, the apostasy of self, and then the judges approved. And the approval of the divorce was mostly on different faith. So it was interesting that this became again strategy by one of the spouse to get divorced from there, from the Islamic court. So the husband in this case mentioned the commit of apostasy by the wife. Actually, the husband had been already done, committed within 10 years. So it was not the actually problem for them to have different religion, but they just took the apostasy as one of the grounds for divorce. It was interesting to me to see this. And also, I would like to refer to the issue of custody in terms of religious conversions. As I have already mentioned, there has been no qualification for custodian specified in terms of similarity of religion. But the judges, when they have to solve the issue of custody with the state of apostasy atau karena adanya konversi agama dari salah satu pihak, judge had different approach to the issue, and the notion of the best interest of the children, maslahah for children, is involved here and judged here. We know that the notion is quite abstract, so they should interpret from the articles that we have in MICoLLS Hukum Islam, but mostly the judges consider that the conversion of one of the parents could be considered as a factor for dismissing the right for custody. I referred again to 2 cases, and I refer again to 2018. A wife wanted to have divorce, and she filed for custody of her 7-year-old child. But it was disapproved by the Islamic Court of Bantul because the mother stayed abroad in Australia. So because of her staying abroad, so she was not awarded the right to custody because she was not considered to be proper to be custodian. But it was interesting that the wife came to the appellate court, ke pengadilan tinggi, and brought her husband apostasy. Before it was not mentioned. And it was interesting that she was approved to have the custody, the right to custody, while she was still staying abroad. So we could see here that the religious conversion is very much relevant to the idea of the parents or the spouses to get what they want. I'm not saying that the judges has decided in wrong way. No, but I'm telling the fact that we could see in Indonesia. So in this case, I have to mention that in 1996, in fact, Mahkamah Agung, Supreme Court has issued a jurisprudence that religion, Islam here is the diviner, or whether or not one mother or father can become a custodian. So it is actually not norms that is inserted into the law of marriage and compilasi Islam, but it is norm that is issued by the Mahkamah Agung. And so by the law, for the sake of children welfare, court could transfer the right to custody from one parent to another one. And this was to guarantee the safety of the children. And so because of that, a religious court often transferred the right of custody from one nominee, non-Muslim to Muslim. So actually, it is not clear whether the spiritual aspect to be guaranteed also include Islamic religions. But we know that judge in the religious court interpret that this is so. And the spiritual safety of the children emphasized by them also has a bearing on religious interest. Actually, I have done a number of research, and recently, I did again a research, and I could see that there has been shift in the recent practices within Islamic court judges in Indonesia. So I could sum up that religious similarity is the priority within the practices of Islamic court in Indonesia. But recently, religion does not always constitute the main factor. Actually, I have to discuss this further, but I don't think that I will have enough time to discuss this. Now I'm moving. If I have still some time, do I have still some time? Maybe you can mention how much time that I have. Berapa lama lagi, so I could saya jadi bisa mempertimbangkan, but I still have some slides. I have to rush. I'm so sorry to ask you this, but I could not hear you. Sorry.
For the Q&A session with you. Excuse me, Prof.
Yeah, I mean, do I have still some time to discuss? I have to present my slides. If I do, then I will go on. And
oh yeah, okay, yeah, okay. You can continue your presentation, Prof.
Okay. So I maybe take like 5 minutes or 3 minutes. Thank you. Now I'm moving to the discussion of actual practices in the context of gender. I have mentioned that we have a number of legal reforms, and state has made several reforms to empower women. But in practice, in some cases, women have become empowered in the issue of divorce and nafkah idah. For an example, although we could see that the women remain powerless in the context in the issue of polygamy, for example, to my analysis, women remain to be powerless. So here, gender notion is often contested as it was considered to have not been based on Islamic principle, but on Western, which is actually misleading. So in terms of polygamous marriage, then we could see that arbitrary polygamous marriage were conducted by husbands. So they conducted polygamous marriage, but they did not come to Islamic court to ask for permission. So the polygamous marriage that had been conducted by them did not involve Islamic court, did not involve the first wife, did not involve the children of the first marriage. Yeah, indeed, we could understand that there were only small cases of legal polygamy in Indonesia because of their arbitrary polygamous marriage. And when they came, I mean, when they did not register their polygamous marriage, they did not go to Islamic court. They often also proposed their polygamous, arbitrary polygamous marriage, unregistered polygamous marriage to be proposed to the Islamic court to be legally confirmed through isbat nikah. It is also interesting. So we could see that there has been permissive or loose interpretation of legal rules, particularly regarding the concept of maslahah and mafsadah. So we often propose the kaidah-kaidah atau legal maxim darul mafasid muqaddaman ala jalbil masalih. And then we are confused about which is maslahah, which one is mafsadah. Is it long or short maslahah? Is it long mafsadah? Because when we, for example, meet the proposal of the husband to the polygamous marriage, actually we also could create mafsadah to the first marriages or to the first wife, to the children of the first marriage. But we often say that it is for the maslahah, and then we try to hinder mafsadah. So we have to discuss this actually further. So then well, I have also to mention that when husband conducted polygamous marriage, the polygamous marriage could trigger divorce. It is not the ground for divorce because if we refer to the Kompilasi Hukum Islam, polygamous marriage does not constitute, tidak merupakan alasan poligami. It is not legally mentioned in the Kompilasi Hukum Islam that someone could petition for divorce because their husbands conducted polygamous marriage. But polygamous marriage triggered divorce. So they come, I mean, the wife came to court to ask for divorce from the Islamic court judges, and they would say that we can dispute, long dispute. But it is often that the dispute that they had resulted from the polygamous marriage of the husband. So I would say this is like a trigger from for the divorce. So I have a very good data on this. I took like 11 putusan cerai gugat, and dari 11 itu ada 3 yang karena polygamous marriage, dan polygamous marriage itu 2-nya itu tidak dicatatkan. So I would say that the polygamous marriage could trigger divorce, although it was not considered to be the ground for divorce. And it was interesting also to mention that Indonesia has moved from such kind of arbitrarily polygamous divorce by issuing the Supreme Court regulator in 2018 yang menyebutkan bahwa isbat nikah untuk poligami tidak tercatat, tidak boleh dilakukan. It is debated among the judges. Some judges actually have become to be progressive and applying, implementing this circular letter, but there are some other still remind to be biased toward gender issue, and they had actually their arguments on this. But I could also see there has been progressive judges, there have been progressive judges, and it is interesting these progressive judges incorporate local values. I don't know if I could discuss this, but one of the example of the decision was issued by judges in Bima on the polygamous marriage. I don't know if I could mention this, maybe in the question and answer about this. So I think I should end my presentation by coming to the to the concluding remarks. So first, I would like to say that religious protection is interpreted differently and is often in conflict with religious freedom, and then constitute a barrier in realizing justice within judicial practices on familial issue. Few reforms have been made departing from classical legal text and challenging the notion of religious protection and leading to that of religious freedom. However, in practice, most judges remain to stick to the classical legal text, as can be seen in the cases of custody and divorce from apostasy of the spouse. The concept of the best interest of the child has been interpreted and looked at by Muslim judges differently. When religion is endangered, judge as other elements of Muslims would at their best protect it. Second, on the issue of women justice, gender concept is also interpreted and practiced in different approach, resulting in asymmetric gender relation to remain. In some cases, cultural expertise, ini yang tadi saya tidak sampaikan ya, cultural expertise of judges help better than concept of gender equality in benefiting women in some cases ya within legal transaction. And third, rather than playing role in helping state modernize legal practice, media and newly born authoritative ulama that take the advantage of media has become a challenge to legal modernization. Nah, kesimpulan terakhir ini tadi juga saya belum sempat sampaikan. I think I should add my presentation. I would like again to thank the committee for organizing this conference and for taking me to this great conference. I thank all the audience, the participants for the attention, and I'm looking forward to the questions, and then I would like to respond to the question. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Prof. Is, for your insightful and thought-provoking presentation. You have brought to our attention critical issues ranging from the tension between religious protection and freedom, the ongoing struggle for gender justice, and the emerging influence of media and religious authorities in legal reform. This perspective provides us with valuable ground for deeper reflection and discussion. So maybe because we have just a bit time, we open a Q&A session just for one question. This is an opportunity for participants to engage directly and ask questions or share brief comments which related to the topic we discussed about. If you have a question, just raise your hand. I think we just open on-site question. Who's the one, maybe? Okay, I just chose one. Yeah. But pardon me, we give the opportunity to Miss Laila. No, it's okay. Again, please. We open just one question. Okay, because we don't have enough time.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
My name is Hadi Subaja and I'm from Faculty of Law, University MICoLLS. Prof, here I want to ask something about how do you assess the tension between religious protection and religious freedom in the practice of Islamic justice in Indonesia? And to what extent does this tension reveal the limits of the state ability to modernize Islamic family law without losing its religious legitimasi? Bagaimana Anda menilai ketegangan antara perlindungan agama dan kebebasan beragama dalam praktik peradilan Islam di Indonesia? Dan sejauh mana ketegangan ini justru memperlihatkan batas kemampuan negara dalam memodernisasi hukum keluarga Islam tanpa kehilangan legitimasi keagamannya itu? Sewaktunya terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Langsung atau gimana, Bu Moderator?
Mungkin kita lanjut satu pertanyaan lagi,
Oke.
boleh? Dari perwakilan dosen, Bu Leila, silakan.
Makasih, Miss Fitri. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
How are you, Prof. It's very nice to have you here.
Thank you. Thank you
I
very
will
much.
ask my question in Indonesia actually because I would like to hear the explanation from the expert in the language that I mostly know. Well, from your let me see. Dari slide-nya, Prof. Ais tadi, well, actually, it's related to my own paper. Saya mengetahui bahwa best interest itu memang highly abstract dan it depends on the judge how they are apply the notion. Tapi hasil dari banyak yang maksudnya saya lihat gitu ya, yang ditulis paper-paper itu apa namanya ya, karena abstrak mendasarkan diri pada culture, knowledge serta value yang dipahami oleh hakim. Nah, kalau dihubungkan dengan paper yang Prof sampaikan tadi, apakah ini ya, hakim di Mahkamah Syariah dan Pengadilan Agama biasanya kan mereka punya eh, punya punya pemahaman sendiri begitu bahwa mereka lebih dominasi pada pemahaman fikih. Nah, pertanyaannya kan ketika konsep ini begitu abstrak terus didasarkan pada hakim dan hakim kebanyakan mendasarkan fikih, apakah tidak bisa kita katakan bahwa tidak ada legal reformasi di sana? Well, I would like to know your answer. Kalau memang ada legal reformasi, in what kind, something like that. Terima kasih banyak Prof atas jawabannya dan kehadirannya. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Should I respond directly, Ibu Moderator, to the questions?
Okay, you can respond directly, Prof.
Okay, thank you very much. I don't know if I can say the words in Indonesian because the first person who asked me question actually before used his good English, but he then turned to Indonesian and was also done by Ibu Laila. So I think it's better for me to say the words in Indonesian ya. Boleh ya? Dalam bahasa
Ya, boleh, Prof.
Oke, pertanyaan pertama itu sulit sekali untuk saya respon sebenarnya ya. Tetapi memang saya harus merespon. Tapi mungkin saya keliru memahami atau mungkin saya nanti perlu dipahami dengan lebih bijak ya. Jadi sudah disclaimer begini ya. Jadi saya memahami bahwa kompilasi hukum Islam itu Mas siapa tadi yang pertama itu menawarkan kebebasan beragama tanda petik, tetapi bukan berarti mengabaikan perlindungan agama. Artinya ketika kemudian kita melihat bahwa pernikahan itu harus dalam satu agama, kemudian juga ada beberapa mekanisme untuk seseorang bisa melakukan pernikahan. Menurut saya ini juga merupakan satu upaya untuk melindungi agama, tapi juga kemudian memberikan kebebasan beragama. Yang mana di Indonesia ini terkait dengan pernikahan beda agama, misalnya kan masih sangat masih sangat hot gitu untuk dibincangkan. Saya perlu menyampaikan bahwa saya pernah diminta untuk menjadi saksi ahli dalam kegiatan judicial review oleh seorang yang ingin merubah ketentuan hukum pernikahan beda agama dengan argumen-argumen yang mereka sampaikan. Tapi kemudian saya oleh pemerintah dalam hal ini Kementerian Agama diminta untuk membantu gitu mempertahankan ketentuan yang ada, bahwa ketentuan yang ada ini sudah sangat merefleksikan perlindungan agama dalam satu sisi dan juga memberikan kebebasan beragama, di mana pernikahan itu ingin tetap dianggap sah jika dilakukan sesuai dengan kepercayaan dan agamanya masing-masing yang kemudian dipahami beragam. Tapi kompilasi hukum Islam melalui pasal 40 sampai 44 kan jelas mengatur bahwa seseorang tidak boleh melakukan pernikahan dengan seorang perempuan jika si perempuan itu beda agama. Bukan beragama Islam, begitu juga sebaliknya. MUI juga memberikan ini. Tetapi dalam konteks di mana mereka ingin melakukan pernikahan beda agama dan negara sudah mengaturnya demikian, ternyata beberapa memang menganggap bahwa kita harus memberikan kebebasan tanda petik ya mereka untuk memilih apakah mereka ingin melakukan pernikahan beda agama. Maka di situ dalam pemahaman saya para hakim dalam hal ini di hakim pengadilan agama menjadi tonggak bagi mereka untuk kemudian melakukan interpretasi bagaimana perlindungan agama harus dilakukan dan dalam waktu yang sama kebebasan beragama. Maka ketika mereka berkonflik dengan negara, negara mengatur bahwa pernikahan beda agama katakanlah dilarang, kita sepakat begitu, walaupun ada perdebatan. Tapi ketika mereka berkonflik dengan negara, mereka mempunyai hak untuk datang ke pengadilan, minta tolong, saya ingin menikah beda agama. So mereka datang ke pengadilan negeri. Dalam hal ini pengadilan negeri sebagai hakim. Ya, di sini bukan ulama, bukan apa, sebagai hakim mereka akan melihat. Saya punya banyak putusan terkait dengan pernikahan beda agama di beberapa pengadilan negeri. Salah satunya adalah satu putusan dari Pengadilan Agama Yogyakarta sudah lama, di mana ia memberikan apa namanya izin bagi pasangan untuk melakukan pernikahan beda agama. Mereka berbeda agama tentu, dan ketika dia datang mereka menikah beda agama. Si perempuan ini seorang yatim, anak yatim yang tidak punya keluarga. Dia memang sering bergaul dengan keluarga non-muslim ini. Sehingga kemudian mereka dekat dan ingin melakukan pernikahan dengan salah satu keluarga daripada non-muslim ini. Dan si perempuan ini teguh dengan agama dia. Dan laki-laki teguh dengan agama dia. Dia bilang, kalau saya mau menikah dan tidak mau repot-repot, saya gampang saja tinggal pindah agama. Saya pindah agama ke agamanya si laki-laki atau si laki-laki. Tapi karena kami ingin melindungi agama kami, gitu kan, kami tidak mau tidak mau melepaskan agama kami, tetapi kami ingin menikah dengan kemudian keyakinan mereka sendiri. Artinya begini, ketika dia memang tidak ingin melindungi agamanya, dia sudah memilih, saya punya agama Islam, I have to protect my religion, saya harus sholat, harus ini dan sebagainya. This is the way of her protecting her religion. Tetapi dia tidak bisa kemudian melepaskan diri dari keinginan untuk menikah. Sama dia laki-laki, I want to protect my religion, tapi juga I have freedom. Gitu. Sehingga kemudian mereka melakukan pernikahan dengan argumen yang seperti itu, hakim kemudian memberikan izin. Tetapi tentu karena hakim tidak seluruhnya harus diberikan izin, akan sangat tergantung. Ini makanya tadi saya ada poin di situ, ada ijtihad tatbiki oleh hakim baik pengadilan agama maupun pengadilan negeri. Nah, itu salah satunya. Dan kemudian saya mungkin kalau mau panjang lebar saya berikan contoh custody ya, tapi nanti yang untuk Mbak Laila. Saya memahami hibdudin itu perlindungan terhadap agama. Ini pemahaman saya, mungkin saya keliru. Jadi kalau I have already decided to have Islam as my religion, then I have to protect my religion. Kemudian ketika kemudian have to protect my religion, bahwa ketika kemudian saya udah mempunyai keinginan untuk protect my religion, tetapi kemudian saya ingin melakukan pernikahan beda agama, misalnya, I have to ask myself, can I protect my religion when I get married with other, with this spouse with different religion, gitu. Kalau seandainya kemudian dalam faktanya kemudian I could not protect my religion, maka berarti saya harusnya kan tidak begitu dalam pemahaman saya. Karena hibdudin dengan di sini berarti protect my religion itu bahwa ketika saya decide untuk ini maka protect religion, tapi saya tidak bisa force other to be in my religion gitu. Jadi itu sih menurut saya. Maka negara menurut saya jika person aja bisa begitu maka negara mungkin bisa memberikan itu. Tapi tentu tadi saya setuju tidak kehilangan misalnya konsep perlindungan agama. Dan ini memang agak sulit karena memang kita Indonesia masih memang berdebat dalam hal ini. Mungkin saya keliru menjawab, tetapi itu kira-kira yang saya bisa sampaikan, Mas. Nanti kita bisa berdiskusi. Terkait dengan yang kedua, the best interest of the child memang menurut saya sangat abstrak, dan itu juga memang di beberapa ketentuan di beberapa negara muslim ya, meskipun di Maroko misalnya menurut saya mereka sangat detail dengan apa yang disebutkan kepentingan terbaik bagi anak dalam konteks pengasuhan, dalam konteks perkawinan kedua oleh si suami, juga the best interest of the children is quite clear. Di Indonesia memang tidak terlalu clear. Kita punya undang-undang perlindungan anak, tapi kadang tidak dilihat juga karena undang-undang perlindungan anak kan tidak terkait family law, terkait banyak hal, gitu, pendidikan, ekonomi dan sebagainya. Jadi nah, kepentingan terbaik bagi anak itu hanya dijelaskan seperti itu, maka kemudian akan dijadikan sebagai bukan media ya, lahan, space untuk para hakim untuk melakukan interpretasi. Maka interpretasi itu tadi tepat sekali ya, akan sangat tergantung pada subjective preference mereka terhadap hukum. Jadi mereka mempunyai preferensi apa gitu kan. Kalau mereka memang preferensinya kepada legal opinion yang mohon maaf ya tidak relevan dengan konteks Indonesia, maka mereka akan gitu. Begitu juga sebaliknya. Jadi menurut saya ketika itu abstrak dan tidak detail, maka ada dua hal yang bisa dilihat. Kalau seandainya para hakimnya progresif, maka mereka akan memberikan putusan-putusan yang mungkin lebih memberikan keadilan. Tapi kalau tidak, maka ketidakjelasan itu akan semakin ini. Jadi akan sangat tergantung kepada bagaimana pemahaman hukum hakim. Nah, itu yang pertama. Jadi sangat terkait dengan bagaimana pemahaman mereka terkait classical opinion dan bagaimana keterbukaan mereka melihat konteks lokal. Yang tadi saya sampaikan terkait dengan kepentingan terbaik bagi anak itu, saya pikir merefleksikan itu bagaimana hakim memberikan pengasuhan kepada laki-laki suami yang satu agama. Tetapi ketika kemudian mereka jauh lagi melihat kondisi yang ada, ternyata mereka belakangan ini tidak lagi. Misalnya dalam penelitian saya di 1 tahun yang kedua tahun ini, ternyata ada pergeseran. Para hakim sekarang ini kalau seandainya dalam konteks custody ada pasangan suami istri berpisah, salah satunya konversi ke agama lain atau perpisahnya karena memang salah satunya karena konversi. Lalu kemudian si perempuan ini kan mempunyai hak atas pengasuhan anak di bawah 12 tahun. Kalau si perempuannya non-muslim, si laki-lakinya muslim, memang secara langsung ini yang muslim yang akan diberikan karena priority adalah itu. Tetapi ketika kemudian lihat lagi ternyata laki-lakinya mohon maaf tidak bisa mengasuh dengan baik. Dia pemabok, dia punya karakter ini. Ternyata ada banyak hakim yang tetap memberikan hak pengasuhan kepada ibu gitu karena dia melihat bahwa tidak proper laki-laki ini, tapi kalau kedua-duanya proper dari sisi karakter maka dia akan memilih yang muslim begitu. Ada itunya, ada situ, tapi juga saya perlu menjelaskan lebih panjang lagi terkait dengan itu. Dan hal-hal lain terkait dengan perwalian, pengasuhan, menurut saya kasus-kasus itu banyak sekali yang mengindikasikan pada itu. Meskipun kita melihat bahwa memang masih banyak yang para hakim di mana ya kami ini hakim bukan hanya hakim, tapi kami juga ulama, kami juga harus memprotek agama kami. Kembali kepada the protection of religion begitu. Mungkin itu ya, karena waktunya tidak ada lagi. Saya khawatir terlalu banyak bicara dan ini terima kasih banyak atas kesempatan yang diberikan kepada saya. Saya mengapresiasi conference ini. Thank you so much. Terima kasih Ibu Moderator dan kawan-kawan semuanya yang hadir. Mohon maaf jika ada hal yang tidak mengenankan, terutama bagi kawan kita tadi yang bertanya di awal. Mungkin nanti kita bisa diskusi. Mudah-mudahan saya bisa dipahami dengan baik. Dan terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Prof, for this opportunity. Thank you very much for a thoughtful question and insightful comment from our participants. Thank you very much also our sincere appreciation also goes to our keynote speaker for their clear, inspiring, and comprehensive response to the questions. Now, ladies and gentlemen, we will continue our session with our keynote speaker. Dr. Helmi. Dr. Helmi. Already here? Oh yeah, okay. Now, ladies and gentlemen, we will continue our session with our second keynote speaker, who will offer another important overview that complement the theme we have just heard. Please stay with us. We move forward to our next distinguished speaker. Now we continue with Asok Professor Dr. Muhammad Helmi M.D. Said from University Kebangsaan Malaysia. He is a respected scholar in the field of family justice, women and child issues, procedural law, and private international law. Dr. Helmi is widely recognized for her contribution to the integration of Sharia and civil law, particularly through his research on legal challenge within contemporary Muslim societies. His notable academic works include studies on domestic violence in a cross-border marriage, and also about social acceptance of legal policy implementation, and empirical study on post-divorce enforcement of court order in Malaysia, which reflecting his strong commitment to addressing real-world legal issues through his research. In this session, Dr. Helmi will guide us through his presentation with the title of The Interaction of Sharia and Civil Law in Malaysia. We certainly hope that all participants will pay close attention to his explanation as the topic raised important issues on how dual legal system coexist and balance jurisdiction and uphold the rule of law in a plural society. Dr. Helmi insight will help us better to understand the complexities and listen that may also be relevant to our own legal and societal context. Dr. Helmi, you have maybe around 20 minutes to present your topic. The screen is yours, Dr. Helmi. Excuse me, maybe you can turn on your microphone.
Hello. Assalamualaikum.
Waalaikumsalam warahmatullahi
Apa
wabarakatuh.
khabar?
Waalaikumsalam.
Uh, Selamat tengah hari. Good day for everyone. Okay, salam daripada greetings from UKM Malaysia. Okay, first of all, I would like to say thank you to the Universitas MICoLLS, especially for Faculty of Law, the Dean, and the respected host today, Ms. Fitri, and also the chairperson is Miss Laila, right? Okay. Okay. Thank you for the opportunity again. For the invitations, for giving the opportunity to share about the what is happening now in Malaysia. Okay, and I'm focusing more on the recent case, which is effect the Islamic law, which is have been enacted in several in the states in Malaysia. We have the 13th state. Okay, and that case has been effects particularly in the family matters, in the criminal matters, which is involved with the Muslim. Before this, we are listening the lecture given by Prof. Wiz Nur Lawati. Okay, a very interesting topic, and she focused more on the family matters. Okay, and I'm now we're focusing more in general matters, which is effect to the Islamic law, and I'm giving the very brief notes of my slides, but I will explain more because it's it close to me. And for your informations, okay, before I'm talking about the subject matter, let me recap to you. Let me remind to you again that Malaysia, okay, particularly in Peninsula Malaysia, we have the dual legal system, which is in Islamic law and as well in the civil law. That two system of law coordinates and operates within the same realm. It means that Muslim cannot avoid from applying this law. And for Islamic law, particularly in the family matters, in criminal matters, which is affected to the Muslim, will be affected by this law. And for your information, pluralism, we cannot avoid, or we cannot deviate from this term, because as for you all know, in Malaysia, the rule of law, ideal of means one law for all, doesn't always gain acceptance in society, which is in Malaysia. We have the different cultural, we have the different, so many religious, and we have so many ethnic diversity. We have Indian, we have the Malay, we have the Chinese, and whatnot. And by referring Malaysia, okay, we have the diversities like that. Okay, and when we are browsing, okay, when browsing in this diversity and the colonial history, okay, hundreds years, okay, being colonized by the British, by the Portuguese, right? They have left us the legacy of the pluralism, which is will apply so many courts, multiple system of laws and courts. As for now, we have the 3 types of law administered in Malaysia, including in Borneo, Sabah, and Sarawak. Okay, we have civil law, okay, which is embedded from the colonized, which is circular, okay, enacted by the Federal Parliament and the 13 state assemblies to cover the civil, criminal, and commercial matters. That's the civil court. Whereas for the Muslim, especially for the personal matters and family based, okay, we have the Sharia court that enacted by the 13 state assembly. Difference. The first one is the federal law, civil court, enacted by the parliament. Number 2, Sharia court, enacted by the state assemblies, which is same to the parliament, but it owes by the state. And the third one is the native law for the native court of Sabah and Sarawak. But today, okay, I'm talking about just 2 conflicting courts only the civil court and the Sharia court. Okay, we don't touch about the native court because it only applies in Sabah and Sarawak. And for your information, okay, the challenges of the legal pluralism are compounded by the Malaysia federal system, which is stipulates the relationship between the federal and the state. We have the 3 types of the component of government. First is legislative, this executive, and the last one is the judicial powers. And when we have so many issues regarding these 3 components of the of these 3 component, and of course, okay, and we are talking about the interactions, how the Islamic law interact with the civil court, and it will, okay, we will talk about the pluralism, raise many fundamental issues, such as the competency, how the federal law made by the parliament can overrule the state powers to enact the law in state. Okay, the law that have been enacted, we call it as the ordinance or enactment. However, in parliament, the law, okay, enacted by the parliament, we call it as an act, ACT. So that's difference. This is very fundamental that I have to highlight about this. Okay. And one more thing, for your informations, okay, even though they are working and works and running operates together, okay, but they have their own sphere. It means that for the Muslim, okay, in order to apply the state law, especially for the personal matters, it only applies to the Muslims. However, okay, and when we are talking about the parliament and they enact the act of the law, okay, for example, I'm touching about the issues of the family law. We have the main law governing this is the law reform and diversity, and it only applies according to Section 3. It only applies to the only for the non-Muslim. So as we can see, it operates the different sphere. However, there is there is a point of meeting between Muslim law and the non-Muslim law, whereby there is an issue of the conversions, and also in the case of the custody and the guardianships. That's the issue of the family law. Okay, and I'm focusing now on not this issue actually, but it relates with the family law because as for your informations, okay, the Supreme Constitutions, we have the federal constitutions, stipulate that the federal state divisions of the legislative, executive, and judicial power under is legislative list. And for your informations, as I mentioned to you, it divides into three. The first one is the civil and criminal law of the secular nature for the whole range of the governance. And these are enacted democratically, elected by the federal parliament. And there is a 13 state assemblies. So that one is the first one, the administered of types of court hierarchies. The second one, the personal and family law based on the Sharia, as I mentioned to you early of this slide, okay, that enacted for the Muslim by the 13 state assembly and the federal parliament, with the Sharia court also enforcing the Malay custom in areas permitted by the state enactment. In the history, okay, we have the old case, the case of the Ramah Latun. Ramah Latun said, okay, in that case, Islamic law is the law of the land. However, okay, after the colonizations, being colonized, Malaysia has been colonized, Malaysia has been colonized, so we adapt, okay, the law imported by the common law, and as for now, okay, we coexist with the Islamic law. So that's why, okay, the conflict of jurisdiction occurs in each and every times the issue arise. Okay, and also, okay, as for informations, as we can see in when we are talking about the conflicts of jurisdiction, okay, we will talk about the first one is the constitutional supremacy. What does it mean, constitutional supremacy? It means the constitution is the supreme law of the land, and any law passed after the Independence Day, which is inconsistent with the constitution, is invalid, to the extent, okay, of the inconsistency. So which is ultra virus. And number two, when we are talking about the conflict of jurisdiction, okay, we are talking about the Islam constitutional position, where it be, where it exists in our Supreme Constitution. It exists, okay, in the article, I will mention to you. The first one is in the Article 3, Article 3, subsection 1, declares that Islam is the religion of the federations, but other religions may be practiced in peace and harmony. So in this, our constitution, it declares that Islam is the religion of the federation. However, okay, any other religions can practice with a peace and harmony. And of course, okay, when we are talking about the federal monarchy, and of course in Malaysia we have the federal monarch, which is headed by the Yang di-Pertuan Agong, or YDPA, and we have also the 9 Malay rulers, must belong to Islamic faith and are designed as the head of the religions of Islam in their territories. And also in the 13 state assembly are permitted to enact the Muslim personal and family laws, which is under on the 26 matters enumerated topics, which has been listed in the state list power in the 9th schedule. And the assembly also have the limited power to punish offences against the precept of Islam. This issue, I will talk this one, okay, as I mentioned to you, is very crucial issues nowadays because we have two cases which is involve challenging the power of state assembly to enact the law, which is involved with the crime, with the criminal. As I mentioned to you, okay, for the criminals, okay, is under the federal list. It means only parliament can enact the law. So it means we cannot deny that Islamic in states assembly can enact the law criminal, which is related to Islamic criminal law, but okay, subjected to the federal list as long it oppose or it against to the or ultravious with the federal list. So state assembly can't enact the law. That one has been discussed further in the next slides. I will talk about. Okay, next slides. Okay, that one also areas of the overlapping. So we have the Islamic banking and finance. That one, okay. There is a one's federal court issues. Okay, but I will touch more about the Islamic court. Okay, and it is next slides, please. Okay, for your informations. Okay, for your informations, as I mentioned to you, we have the state assemblies in 13 states, and they have the limited power to enact the law to punish the wrongdoer who committed the offences. However, Sharia court exists at both the federal and the state levels. In the federal, okay, we have Department of the Judiciary Islamic, which is a federal, okay. And also in the state, we have also in the Mahkamah, we call it Mahkamah Sharia, is governed in the state. For example, in Selangor and Wilayah Persekutuan. And they don't have any for Sharia court. They don't have the wide power compared to the civil court, and just only have the limited criminal jurisdictions. Okay. However, there is interesting amendment or development in 1988. Okay, which is Sharia courts. Okay. Are independent of the civil courts in matter with the Sharia court jurisdictions. It means what? It means during the amendment 1988, okay, there is a separations between civil court and Sharia court. And okay, anything which has been been tried in the Sharia court, so civil court cannot touch, cannot interfere with the power that the court can hear the case. Okay. And for your information, when we are talking about the Muslim, always we are referring to the Article 153 of the Federal Constitution, because majority in Malaysia is a Malay ethnicity. So in the ethnicity, a Malay is defined in Article 160, subsection 2, by reference to 4 characteristics, being a Muslim is one of them. So it means, okay, Malay must be a Muslim, can converse in language, bahasa, and whatnot. Okay. And also, like all laws, okay, for your information, state legislation on Islam is subject to the judicial review, okay, on the ground of the unconstitutionality. and the Sharia court and Sharia establishment are not exempted from this judicial review in the higher civil court. And the parties or plaintiff are able to the petitions against the state legislation deemed to be unconstitutional with the federal court as the final arbiter, right? And please move next slide. Okay, for your information, okay, I have highlighted that there are so many challenges in the dual legal system, which is involved the pluralism. Okay, the first one, lack of the clear legal framework on overlapping issues. Until nowadays, okay, there is no guideline, there is no framework that how to avoid the clash between these two legal systems. Even though we have the amendments, as I mentioned to you, 1988, however, it still occurs up until now. And also, and it not become academic because until now, okay, we have so many cases which challenges the power of having the enacting the law, and also challenges also regards to the procedural inconsistency between the courts. Okay, some the issues in the procedure has not been governed well, and also because of that, so there are so many issues arises. For example, in the family matters, okay, say for example, one of the parties had converted or converts or back to the the old religion. So how the court can decide, it will cause the issues, cause the trouble from that thing. And also, okay, we need the coordination, especially in the between the issues between the federal and state authorities. And due to the lack of the as I mentioned to you, we have the the challenges. Because of that, okay, we have the lacking constitutional literacy. There are some widespread but mistaken belief about the applicability of the Sharia in Malaysia, particularly in the case we're having secular court or civil, okay, and partly religious constitutional system. And first, there is no understanding that due to the secular definition of the concept of law in Article 160, religious rules are not automatically part of national legal system unless posited into the law by the Parliament or State Assembly, by intention of the Parliament or the State Assembly. That's one cause trouble to the Muslim in Malaysia. Okay, next slide. Next slide. Right. Okay. I will talk about we have there are three cases. The first one is Indira Gandhi case. Indira Gandhi say is quite famous. It relates with the custody between conversion. I'm not talking about this case. I'm talking about the case of Iki Putra, because Iki Putra is decided in the federal court, which is binding to us. So we have to follow this case. Nick Eileen follow the Iki Putra case. So I will focusing on more on the Iki Putra. Okay. Before I'm briefing to you about what are the facts of this Iki Putra case, okay, let me explain to you about the power to create and punish Islamic offenses. Where are the where are the powers? Where are the sources? Can State Assembly enacts the punishment for the Islamic offenses? The answer lies like this. For your information, the power to create and punish Islamic offenses is subject to the following restriction. The first one, criminal law, is largely in the federal's hands. It means only Parliament can enact the law. However, the state can punish one type of the Islamic offenses, which is offenses against the precept of Islam. What does it mean by precept of Islam? So one precept of Islam means the offenses which want to propagate, to want to destroy, want to damage the Islamic reputation. So we can, we can take the actions against this precept of Islam, the offender. What this word mean is nowhere defined in Constitution. Precept of Islam is not defined. It's not defined in any federal constitutions. However, in the case of Ni Elin Zurina, as I mentioned to you, federal court had that the word refer to the offences. They are purely religious in nature and do not extend to the ordinary criminal law and the procedure. So it means that, okay, in order we want to apply the Islamic law in focusing for the Islamic offenses, so we must apply only the offenses again the precept of Islam has been discussed and decided in the case of Ni Elin Zurina. That the first restrictions. The second restriction is the second Sharia court only have the jurisdiction over the person professing the religion of Islam. It means non-Muslim, we cannot execute, we cannot prosecute the non-Muslim. And the third one, the crimes punishable in the Sharia court must not relate to any matter in a federal list. Federal list means any offences that has been stated in the federal list, including the penal code, and this one. So when it comes like this, okay, so it means that the state's power have the limited power to prosecute the offender. And number 4, okay, condition number 4, in order to apply for the Islamic punishment is that crimes punishable in Sharia court must not relate to any matter covered by the federal law. It means that any offense, okay, already deal with by the federal law at the inception of the is outside of this Sharia court jurisdictions. That's number 4. Number 5, sorry, number 5 number 5 restriction is the jurisdictions of the Sharia court is in respect of the offences must be conferred by the federal constitution. It means that the derivative law, the Sharia court, okay, only provides only offences that which is punishable by 3 years jail, imprisonment only 3 years. Okay, they have the limited power. 3 years imprisonment, 5,000 fine, and 6 strokes only. 3, 5, and 6. So very limited jurisdiction. In order, okay, that's the restriction in order to apply the Sharia offenses to the Muslim. By having said that, okay, I will talk about the Iki Putra case. Iki Putra case, which is very interesting, because it involved with the Muslim, actually, and there is involved with the applications. Okay, as I mentioned to you, remember the judicial review. What the federal constitution can review? One of it is the Islamic law, which have been enacted by the state assemblies. Okay, in this case, yeah.
Dr. Helmi, we have a bit time to continue our Q&A session.
Okay, all right. Can I finish the facts of this case? Only one.
Yes.
Okay.
Yeah. Okay.
Okay. For this case, for Iki Putra case, okay, this case involved with the Muslim. There is an application by the Iki under pursuant of the Article 4 Federal Constitution to challenge the validity of the Section 28 of the Sharia Criminal Enactment regarding the sodomy. Okay, the anal sexual intercourse through the sodomy. What happened in this case? He challenged, okay, he contended that the sodomy offences is under the purview of the federal constitution in the federal list, and also purview under the criminal law enacted by the parliament, not the state. So I just summary. In this case, the federal court decided that in favor of the Iki Putra. They agree that state assembly can only enact the criminal offense only to the matters that precept against Islam. And this case, okay, has been followed by the Elling case. So, my conclusion, I would like to conclude that the coexistence of the Sharia law and civil law defines Malaysia's legal uniqueness. And despite clear jurisdictional boundaries, it overlap, persists, and exists up until now. And hopefully, the harmonization and judicial cooperation are key to justice and consistency. Thank you. That's my short brief of these issues. And over to you, moderator.
Thank you, Dr. Helmi. Thank you very much for your comprehensive and insightful presentation. Your explanation of the interaction between Sharia and civil law in Malaysia has provided us with a valuable comparative understanding of how dual legal system can coexist and evolve to address complex societal and legal challenges while upholding the rule of law and ensuring justice and harmony within a plural framework. Ladies and gentlemen, we have now heard from our distinguished keynote speaker, which from Dr. Helmi, covering the critical relation about the legal pluralism issues from Malaysia. Now we will proceed to the Q&A session. This is an opportunity for all participants to engage directly and ask questions or share brief comments which related to the topic we discussed about. If you have questions, please raise your hand or use the raise hand in your pictures or type your question in the chat box and kindly introduce yourself before speaking. Let us begin the discussion. Maybe in the online, anyone have question?
Actually, if I may, I would like to ask question, if I may.
Yeah, my pleasure. Please, if you have question.
Yeah, please.
Okay, so this is my turn. Thank you so much. Assalamualaikum warahmatullahi wabarakatuh. Terima kasih banyak. Thank you so much, Bapak Helmi, for the very enlightening presentation. I really enjoyed the presentation. So you have, I think, provided with so many information about the legal system in Malaysia. You have also provided with us with the examples of how overlaps and persists in the legal system in Malaysia. I have two questions. It is quite detailed questions, and it is very much related to what I have discussed. I've been discussing before. So this is about the issue of FRIDA and its impact to the custody and its impact to the what is the fate of marriage. So as I have mentioned that in Indonesia, when someone committed custody, the commit apostasy. Sorry, I'm overlapped. Yeah. When suppose in a marriage committed apostasy, then the apostasy, as I have already mentioned, does not constitute the ground for dissolution of marriage automatically. So there should be another spouse who come to court and to ask the court to divorce him or her. But in the context of Malaysia, I'm not sure if I understood well, but this is what I understood. So although this is also the ground for divorce, but this I may be misunderstood, but is it the spouse of the apostasy? Is it only the spouse that could come to court to dissolve the marriage, or is there any other parties that could come to court? For example, the family of the party. Because at glance, I understood that although this is the ground for divorce, but this is also quite related to the classical legal opinion. That other parties could also come to court to ask the Islamic court or the court in general to annul the marriage of the spouses, one of whom commit apostasy. This is one questions, and the other one is related to the inheritance. I know in Malaysia, as you have already mentioned, legal pluralism also exists, particularly because it is very much relevant to the federal system or something like that. So what is about the right of a non-Muslim family to inheritance? So we have wasiat wajibah in Indonesia, although it is not a legal rule, but this is like the legal interpretation by Muslim judge in Indonesia who often awarded the share to non-Muslim, the share of property to non-Muslim in the system of wasiat wajibah, not in the system of inheritance. What I understood from your legal system, there is also the concept of wasiat wajibah or something else. So thank you so much. This is quite detailed question. This is related to the practice of family law. Again, thank you so much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much, Prof, for the thoughtful question. Any other want to give question to Dr. Helmi? Who's? I think we just have one question from Prof. Ace. Dr.
Okay.
Helmi? Now I would like to
Thank
invite
you,
you to kindly
Ms.
respond the
Moderator.
question.
Thank you, Prof, for posting these two questions. That's very crucial. And for your informations, okay, I'm answering the first questions. Who will initiate to annul the marriage, right? Okay, in case of the conversion or Rida, right?
Yeah.
Oh,
I mean,
okay.
would dissolve the marriage,
Okay.
the spouse themselves.
Who will dissolve the marriage?
Yeah.
Okay. Let me explain to you. There are two situations. This whereby the spouse is both Muslims. Okay. Both are Muslim, and one suddenly, okay, after getting married, and one of it convert to another religion,
Yeah.
right? Okay. Okay, the first situation is the answer, okay, because in our Islamic law, this has been enacted in the state assembly. We have the hard law, we don't have the soft law. Hard law means it can be enforced, and we have the Sharia court. That one is being dissolved automatically by application for those who are not means the party who still Muslim, means the parties one of the spouse which is still in Muslim, they can apply to the Sharia court to dissolve the marriage. Has been vested under the section 52 for the duration of the dead marriage. The first situations. Okay. The second situations is both are non-Muslim. They are getting married in the under the law Reform and Divorce Act 1973. So this means initiating in the civil court. So it means one of the parties who convert to Islam. So the parties who are non-Muslim can apply to the court to resolve that marriage. So that's the second situations. And this remedies has been provided under the first situation is in the under the Islamic law, enactment or ordinance in you can resolve in under the Law Reform in Divorce Act. That must be been applied by the parties which is non-Muslim. Parties who convert to Islam cannot apply, cannot use because he's the Muslim. So for your information, the LRA law reform divorce only apply to the non-Muslims. So only that means everything begin from the in the non-Muslims law. So we have to end it with the non-Muslim law also. Everything which is initiated by the Islamic law, so we have to end it using the Islamic law. So that's the rules and has been vested in our law. And the second question is regarding the inheritance. Yes, we are same about this. Okay, we have the wasiat wajibah also. If we want to know, we have we call it under the mufti, the Majlis Fatwa. We apply that one. And but we don't have the specific law regarding this wasiat wajibah to the non-Muslim. But for in the fatwa we have it.
Okay.
So we can enforce that one.
Okay,
Yeah, I think that's all from.
Okay, thank you very much for the thoughtful question, and also sincere appreciation also goes to our keynote speaker for the clear, inspiring, and comprehensive response to the question, especially about the marriage divorce process in Malaysia and legal pluralism issues. Your judgment truly enrich our discussion and reflect the strong academic spirit at MICoLLS aim to foster. Thank you all participants for your thoughtful question and reflection in this session. Once again, our deepest appreciation to both keynote speaker in this session, Prof. Who is still with us here, and Dr. Helmi for the valuable insight and contribution. We look forward, inshallah, to seeing you again in our next academic gathering and future collaboration, maybe, inshallah. Yeah.
Okay, thank you.
Ladies and gentlemen, we have now reached at the end of our morning session. We will take a lunch break, allowing everyone to rest and recharge before we proceed with the next agenda. Please enjoy your lunch and take this time for informal networking and personal break. We will resume precisely at 2 p.m. with our next session, so kindly be back on time. Thank you and see you after the break. Assalamualaikum warahmatullahi wabarakatuh.
Ya,
Ya,
saya
terima kasih juga, Prof.
dan
Ya.
sukses untuk konferensi berikutnya, untuk sesi
Ya.
berikutnya. Terima
Ya,
kasih
ya.
semuanya Bapak Ibu
Sampai
dari
jumpa di
MICoLLS
UIN,
Unimal.
Prof.
Ya, Mbak Laila, thank you so much ya. Ya, I
Ya.
thank all of you from MICoLLS.
Ya.
Thank you so much.
Ya.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Terima kasih for your coming today. Please, kembali lagi di jam 2 ya. Kita masih punya 2 keynote speaker dari Belanda dan South Africa. Harap banyak yang akan bertanya sebagai persiapan untuk studi lanjut nanti. Siapa tahu South Africa punya banyak beasiswa dan Leiden University punya banyak beasiswa untuk magister. Jam 2 insya Allah di ruangan ini kembali ya.
Indonesia is the most beautiful land in the universe. The land where we were born, the nation where we grew up. So many colors that live together in peace. With a million timeless treasures, with an abundance of natural wealth. Indonesia is not just wonderful. Indonesia is a wonderland. Indonesia is the most beautiful land in the universe. The land where we were born, the nation where we grew up. So many colors that live together in peace. With a million timeless treasures. With an abundance of natural wealth. Indonesia is not just wonderful. Indonesia is a wonderland. Indonesia is the most beautiful land in the universe. The land where we were born. The nation where we grew up. So many colors that live together in peace. With a million timeless treasures. With an abundance of natural wealth. Indonesia is not just wonderful. Indonesia is a wonderland. Indonesia is the most beautiful land in the universe. The land where we were born, the nation where we grew up. So many colors that live together in peace. With a million times treasures. With an abundance of natural wealth. Indonesia is not just wonderful. Indonesia is a wonderland. most beautiful land in the universe. The land where we were born, the nation where we grew up. So many colors that live together in peace. With a million times treasures. With an abundance of natural wealth. Indonesia is not just wonderful. Indonesia is a wonderland.
Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone. Welcome back, ladies and gentlemen. I hope you had a refreshing lunch break. We will now continue our keynote session in this afternoon. It is a great pleasure and honor to welcome you to the 5th MICoLLS 2025, especially in this afternoon session under the theme Legal Pluralism and Local Wisdom, Harmonizing Customary, Religious, and State Law in a Global Context. I think Prof. Jenin Ubing already joined with us here. Prof, I'm sorry if I spelling wrong your name.
Not at all.
Yeah, thank you. Our third speaker is Prof. Jenin Ubing from Netherlands. It is my pleasure to introduce our third keynote speaker, Prof. Jenin Ubing, Professor of Law, Governance and Development at the Van Vollenhoven Institute, Leiden University. She is a highly respected scholar in the field of legal pluralism, customary law, and governance, with extensive field research conducted across Africa, including Ghana, Namibia, South Sudan, and South Africa. Prof. Jenin has also served as president of the International Commission on Legal Pluralism since 2015 until 2024, contributing significantly to global discourse on how state law interact with local and customary legal system. Among her notable contributions, Prof. Jenin has extensively examined how customary authorities, local communities, and state institutions interact in complex legal environments. Her research offers critical insights into land governance, community representation in resource management, gendered power relation, and the role of local mediator in post-conflict justice system, particularly in Africa contexts such as South Sudan and beyond. Today, she will present her paper titled about legal pluralism in the 21st century. The global, the national, and the local. In this presentation, she will guide us through the evolving landscape of plural legal system, exploring how global frameworks, national policies, and the relation of local practice and shape justice in diverse societies. Prof. Jenin, the screen is yours.
Would you like me to bring up my own PowerPoint, or are you bringing that up for me?
You can share your own PowerPoint, maybe.
Okay, let me see. Okay. But then can I put it here? Are you seeing full slides now?
Yeah, of course. Yeah,
okay.
You will see it.
Okay. Well, thank you very much. Let me just check how this is working. Okay. I think it works like this. Okay, well, thank you very much for that kind introduction, and thank you very much for allowing me to speak at this conference. I'm excited to be able to speak to a group of people whom I've been told are very familiar with the concept and studies on legal pluralism. I was asked in line with the conference theme to talk about legal pluralism in a global perspective, which in a way is always challenging because a lot of us work very much on local case studies. And from that, we try to extrapolate to national lessons and possibly a little bit in comparative perspective. But I noticed that a lot of people doing this work need to do quite deep field work. And therefore, most of them focus on one locality, maybe two localities. And then, of course, there's a risk of saying, oh, you know, customary law is like this, or legal pluralism has these challenges that might be very different in very different localities. Now, I'm mostly an African scholar doing some comparative work. I'm definitely not well known with Indonesia or Aceh. So I thought maybe I could be most useful for you in this keynote. If we look at the number of different systems and try to take out some of the lessons that and the differences and the lessons that come from those differences. So my disclaimer also is I mostly focus on customary law. In the areas where I do that, there isn't much Sharia, so there isn't much interaction also between the customary and the religious. So my presentation will be heavily focused on the customary. Okay, so what I intend to do for today is briefly introduce the term legal pluralism, although you'll be familiar with it, but mostly the evolution of the scholarly field. And then speak to legal pluralism in different contexts, where we look at examples of Ghana, South Africa, Australia, and if we have time, Suriname, and then draw out some conclusions on this global, national, and the local. So let me start with the first part, the term in the scholarly field. I'm assuming that the definition is known, right? Legal pluralism is usually defined as the presence of more than one legal order in a social field. And of course, it was very much a response to a legal centralist ideology that law is and law should be law of the state, and any other type of normative ordering, therefore, is hierarchically subordinate to state law. The concept, when it started, in a way reacted to a trend also in classical legal anthropology at the time, so until the 1950s and 60s, very much was editing out the state in a way. Anthropology studies at that time usually focused on quite small, isolated, ideally untouched societies. And researchers, therefore, largely studied these customary legal systems as autonomous legal systems and disregarded the influence of the state and the colonial government on the customary. And they were unconcerned with any interaction on this as well. Now, at some point when legal anthropologists did become more interested in the role of the state, they mostly focused first in the sense of methodology. They focused on disputes and disputing, and that in a way led them to overestimate the role of the state. Regarding customary law, possibly even as an invention by the state, and kind of ignoring that much of law formation and application is taking place outside of disputing and outside of the control and the influence of the state. So in the decades following the introduction of the concept of legal pluralism in scholarly field, we see that étatists, so the people who believed is legal centralism, right, from the French état, state, they continue to reject this term legal pluralism on the premise still that only normative orders emanating from the state could be considered law. And legal pluralists countered that for many people and in many places, state law wasn't the dominant normative order. It was there, but it wasn't their dominant, most important normative order. And that people often choose when to use which normative system and which related dispute settlement fora for instance. So legal pluralists were saying legal centralism is a construction, a legal construction. Or as Griffith said, it's a myth, an ideal, a claim, an illusion, while legal pluralism is actually the empirical reality. So this term legal pluralism was going to put the issue of competing legal orders center stage. And originally, this was largely done or talking about the relationship between state law and customary law in former colonies. But then over time, there was a realization that legal pluralism is a characteristic of virtually every society. And studies of legal pluralism started to include highly diverse fields such as the New York garment industry, farmers and cattle ranchers, religious courts, but even sumo wrestlers, stand-up comedians, and slum dwellers. As I said, legal pluralism kind of rejects these dualistic distinctions with state law on the one hand and non-state forms of ordering in the other, but rather says they interact, they have a connection, they're in a dialectic relationship, and we need to study that relationship. And this is where terms such as the semi-autonomous social field from Sally Folk-Moore, interlegality from de Souza Santos, and vernacularization from Sally Engel-Mary, but also hybridity used by many different authors were introduced to describe these interrelations. Now, the general acceptance among lawyers and social scientists only happened at the end of the 20th century when we see that the expansion of globalization and therefore the growth, the proliferation of international law and transnational law started to take on such dimensions that even lawyers could no longer claim that it is nation states that make all law, right? That are the only legitimate source of lawmaking. And once this was accepted for supranational law and transnational law, basically there was also space to accept this for subnational levels and legal pluralism within national legal systems. At the same time, we see that the last decades, there is an increasing global recognition of legal pluralism, and particularly the right, particularly connected to indigenous communities and their rights to their culture, to practicing their own customs and their own governance structures, and also a protection of their rights, particularly in connection to their lands. So think of ILO Convention 169 here from 1989. Of course, very prominent in Latin America, but I know that in Indonesia, it's also been heavily taken up to discuss issues of other communities. Okay, so this just as a little bit of a background. So we see an increasing recognition that legal pluralism is everywhere. We see an increasing recognition that some types of non-state law, particularly connected to indigenous peoples, require being taken seriously. But then what does that entail, right? What kind of questions does it raise? And this is actually very different in different contexts. So that's why I'm going to move to these 4 examples, 3 or 4, depending on the time, where I'll show you how the different context and different history and the different makeup of these countries really determine what are the main debates around legal pluralism and recognition and incorporation and the connection between state law and non-state law. Okay, so let's start with Ghana. Ghana was colonized by the British. It has about the same timeline of colonization as Indonesia, and it had relatively few white settlers. Administration was via indirect rule, which in a way started from the idea of respecting and working through existing local authorities. Nevertheless, there was definitely also interference with these authorities and with this law because in some cases, there weren't any suitable chiefs, so these were invented. In some cases, there were chiefs, but just too many little ones, and they created a hierarchy to, again, make it more governable. And also on customary law, while in principle they accepted most of it, they immediately said that most of the higher level criminal cases needed to go to the state, but also customary cases could go to colonial courts. And then via the use also of the repugnancy clause, there was piecemeal interference with this customary law. What this also did is that it, in a way, eroded some of the checks and balances that within the communities existed on traditional leaders, in the sense that where these traditional leaders used to be accountable to their communities, and if their communities weren't happy, had ways to deal with such chiefs or get rid of such chiefs. Now, as long as the chiefs were smart enough to stay good friends with the colonizers, with the colonial government, then even if their own people were very unhappy with them, they would still remain in power. So this gave them more options for more authoritarian rule. Now, in 1957, Ghana is the first country in sub-Saharan Africa to gain independence. And we're at a situation where, in a way, everyone is indigenous. right? Which means the term is not used, not in the sense of ILO Convention 169, because if everyone is indigenous, then no one is indigenous, right? You're just Ghanaian in a way. So almost the whole population is member of a traditional community, although some people who've moved to town might feel less connected to that. And what's important also to understand is that traditional communities and customary law, therefore, are not connected to a minority, and they're not necessarily connected to marginalization. I mean, there are marginalized areas in Ghana, particularly the north, which is drier, more remote, further away from the capital and from the ocean. And yes, they do feel marginalized, but this is not connected to being a minority, a traditional community, or having customary law. Also important to know is that state authority isn't much contested. There's no groups who want to secede or be autonomous, or of course there's a lot of grumbling about, to what extent this government is doing its job well, but it's not really about the state and not being connected or want to secede from the state. So after independence, it was again confirmed that customary law was a source of law now for everyone in the country. Traditional leaders were recognized. Originally, the state had quite an influence on this recognition and thus on the selection of these chiefs. That had quite negative consequences in the sense that traditional leadership became quite politicized, and there was a lot of local violence around this. And as a result, in the new constitution in 1992, they decided that the recognition by the government was more of a rubber stamp, whereas these leaders were locally elected or selected on the basis of customary law. This recognition of traditional leaders is alongside elected local government. Let me just make that clear. At the same time, customary land rights are recognized, and in Ghana, that makes up 80% of the territory. So we're talking a huge recognition there. And this land is governed by traditional authorities. So the questions of legal pluralism that we see are largely questions of governance, not so much of sovereignty or marginalization. And some of the main disputes are around the fact that these eroded checks and balances during the colonial period, they have not been restored. And this leads to conflicts about accountability of chiefs. So these are mostly conflicts between chiefs and their own communities, for instance, connected to natural resource management. Okay, country two, which is quite different, is South Africa. Also a history of colonization, occupation by the British and the Dutch. At some point, they gain their independence from Europe, but all the white settlers are still there, and we get a system of apartheid. The core policy of apartheid was separate development in homelands. Homelands was where the majority of the Black population was forcibly moved into. It was originally 7%, later 13% of the least fertile territory of South Africa. And these homelands were governed by tribal authority. And what they were really stooges of the apartheid government. They were made to do very unfavorable and different things than before. So this was a heavy interference with the system of traditional leaders, also because many people were moved, right? So they were also moved under chiefs they had never recognized before. And again, there were hierarchies created that hadn't existed before as well. So they might be under their own chief, but then not recognize the senior traditional leader. And those senior traditional leaders, because they had to do such negative things, many of them protested, and basically everyone that protested lost their position, and someone else was put on that position by the apartheid government. So heavy interference in the system and a heavy reduction of local checks and balances. Very oppressive regimes in a way that when a lot of resistance against apartheid came, this was largely visible as resistance against their own tribal authorities. At the same time, we see a creation of official customary law being pronounced in state courts, being laid down in codifications, which again differed a lot from the living customary law because this is an official version that benefits apartheid governance. So early 1990s, we see a process of democratization, and there's a big debate. Can we retain traditional authority, who we see as these stooges of the apartheid government? The answer, for many political reasons, actually, that I won't get into, is yes, we need to retain it. We will retain it, but subject to the Constitution. Now, what this means is already immediately a big debate because the traditional leaders claim, sure, subject to the Constitution, but it can't be subject to the gender equality clause because that our customary system is just patriarchal. Big debate between women's groups on the one hand and traditional leaders on the other hand, won by the women groups, no, fully subject to the Constitution. So yes, it's retained, but it's said that some actions need to be taken to undo apartheid distortions. One, there need to be elected and female traditional councillors in the chiefs traditional councils. Two, a commission is set up that is to deal with all these chieftaincy disputes. I just told you that many chiefs were removed and someone else placed on there. Now, this was, of course, the time to undo that and to discuss these disputes. Yes, they recognized traditional government, but also they were setting up wall to wall, so fully in the country, local government, elected local government. And the Constitutional Court, also newly created after this change to democracy, in one of its early decisions decided that living customary law, so whatever is found in the locality, trumps official written down versions of customary law that were so heavily skewed by apartheid governance. So what are the main issues around legal pluralism here? Well, customary law here is definitely connected to marginalized communities, not of a minority, but of very marginalized communities, where at the same time, these marginalized communities have been more and more, they found very lucrative, extractive, it says communities, but that should be resources in these areas, particularly platinum mining, oil mining, etc. Now, while I just said, right, they one up, oh no, that doesn't show. Okay, they try to undo some of the distortions, but they haven't been very effective. Now, at the same time, we see from the early 2000s, so one decade into the new constitutional era, new legislation being made by the lawmaker that strengthens this position of the senior traditional leader, the top of that traditional leaders that most people don't recognize or feel they've been put on there. And those were the worst stooges of apartheid government. And again, this legislation does not talk about checks and balances, does not talk about accountability. Now, why is this happening? Exactly because of these new lucrative extractive resources, because the government wants quite a direct link to that. And because of something in the constitution, it's the traditional communities that have to give access to mining. The state can't just force them into it. And of course, it's easier to make a deal with one chief and make that one chief very rich than to make it with a whole community. And that's going to lose its land and gets pollution and blasting and all of that, right? Now, the effects, again, in a way like Ghana, but in a much more stark environment, is very violent conflicts between communities, these former homeland communities, and their senior traditional leaders who team up with extractive governments, companies, and government. And government isn't just in it for development of the country. There's also a very clear aspect of the neo-Black elite, which is both in government and in business and revolving doors in and out, directly profiting from lucrative deals around mining. Okay, third, and I'll go a little bit more quickly here, I think. What are we doing on time? Yes, is Australia, which, as you know, was colonized by the British, but never decolonized, right? So it did achieve independence from Britain, but the relationship with the indigenous people was never decolonized. The indigenous communities consist of very many different groups, so it's not one group that talks with one voice or one representative, but it was decimated through the actions of the British. And this group is still heavily marginalized. Now, there wasn't a system like indirect rule, and that also meant that limited interaction between these groups and systems, right, the state and the indigenous law was less impacted by state law. So what you see in Africa is that earlier understandings of customary law and customary land rights as something that is, not can't be sold and that remains within the community and that needs to be dealt with in a way that earth is protected, etc., has all moved more towards, land that is alienable, that is commercial, so that has changed really due to interactions with the state, with a more monetized economy. We see much less of that in the indigenous communities in Australia. So they still very much have a different understanding of law and of the relations between humans and nature or earth. More law isn't made by man, law is just out there, and it's connected to what they call the dream world. Now we have a court decision from 1992, Mabo, where they decide that terra nullius, the terra nullius principle was legally overturned. This was, of course, the principle that said that, for instance, the British here could move in because there were no people living there, either from the reasoning that the indigenous people were not people but savages, or because of a reasoning that it was unowned because the forms of land use was not about ownership. So this Mabo case says that native title would now be recognized. But what is that native title? It means an acceptance of indigenous land rights, but on the terms of the colonizer, right? What the colonizer or what the state recognizes is a type of land right the indigenous people do not adhere to, they do not believe in, they do not share. And in a way, it does bring the indigenous communities and their land more into the fold of the state and might make it more commercial and transferable, etc. And this is heavily challenged by indigenous peoples. There's a particularly interesting article by Irene Watson who talks about being buried alive, because what they want is sovereignty and an understanding and acceptance of their type of law and earth-human relations, which is very different from what they're getting now. I think I'll skip Suriname because I think I'm taking too much time. Is that, or am I okay?
It's okay, Prof. Janin. We have quite long to,
Okay, then let me
present.
add this because it adds a nice other example and it's not too long. Okay, so Suriname is again a very interesting country. It had a small indigenous population. Oh, sorry, I'm doing something wrong here. Yeah. When it was colonized by the Dutch, this is a very different timeline from the ones we have in Africa and most of Asia. So this colonization started already in the 17th century. The indigenous community, the Dutch tried to put them as slaves on their plantations, but A, they heavily resisted, and B, many of them died. So they weren't very suited for that type of work. So as a result, they kind of were left alone in the inlands of Suriname. Suriname is 90% forest, right? Where the Dutch started to bring in people from Africa for slave labor. Now, some of those remained for a long time. Other parts of those groups escaped and they moved also to the forested areas. And at first, they were raiding other plantations to try and free other slaves. And as a result of that, of course, the colonial government was quite, unhappy with this, and this led to peace agreements where there was an agreement that if these maroon communities, these runaway slave communities, would leave so stop raiding other areas, then they would be left alone and they would be left in peace. So they also formed quite autonomous societies in the inlands of Suriname. So currently, about half the population that originated from Africa is part of those more maroon communities, although a lot of them have moved back to like Paramaribo and more the coastal areas, and half are really like the former slaves that didn't run away, but the descendants from those people. Then when slave trade and slavery was labor was abolished, the Dutch instead brought people in, including from Java and from India, and a little bit later also from Hong Kong, brought them in as contract laborers, who didn't have a much better position actually than the slaves before them. So this is still really determining the makeup of the current society, with the indigenous groups only being about 3% and the other groups being the main groups. They gained independence in, it says 1970, but that's actually incorrect, and it's 1975. So in Suriname, the discussion around indigenous peoples' rights and maroon rights that is very much around ILO Convention 169. So it's very much about an interpretation of indigenous peoples' rights. And there have been several court cases at the Inter-American Court of Human Rights about these rights and about the rights of these people to also protect their lands. And the Inter-American Court has said maroon communities have a similar relation to their land as indigenous groups. So they're also protected by ILO Convention 169 and other international instruments. So there are a number of decisions of the Inter-American Court starting 2 decades ago, 2005 actually, where both indigenous and maroon groups are said to have right to land, which need to be protected and demarcated also by the state. But despite these decisions, nothing basically happened. There's no official regulation, recognition, or demarcation. There has been a legislative process going on for 20 years with bills being brought in, retracted, changed, brought in again. But no effect yet. There isn't new legislation on this. And this is again revamped by the new president who took office 2 months ago or 3 months ago. So the inland communities, in a way, are still, to some extent, left alone. But the biggest challenge for them is around natural and extractive resources that are in or around their traditional habitat. This is really fought out around the international. So you see here, sorry, that was what I wanted to say. You see here that the Inter-American Court and this ILO Convention are really important for them in a way to get that right, which is recognized by the state on paper. But you also see it hasn't done anything. But there's a PhD on Indonesia also showing how the fight for Adat people's rights also is now using this indigenous peoples and ILO Convention 169. And we were talking about whether this is helpful, right? Is this easier if you can use that international rhetoric and these international instruments? And in a way, yes, because there's international resonance, there's possible international support, right? On the other hand, not so much. It's in a way the same struggle, which was before to get maybe Adat land rights recognized. Now that would flow from a recognition as an indigenous community, but it's just as hard to get recognized as that indigenous community. But that's just a little side to Indonesia. But Suriname and Latin America, all these discussions around legal pluralism are heavily around this ILO convention and around jurisprudence of the International Court of Human Rights. Okay, now why or what am I trying to tell you by discussing these different countries and different contracts, right? So I think one thing we need to understand is that questions of legal, so I think what this shows is that questions of legal pluralism and the governance of legal pluralism, they vary very much in these different contexts, as you can see. And one variable is really about the relationship, the variable we usually think about is the relationship between the state and the indigenous community, indigenous state, indigenous customary, traditional adat, whatever you call it, but the relationship between the state and the local community. And what we need to understand here is that regulation of non-state normative systems will always be intertwined with questions of political power and control. Are communities integrated or are they excluded? In what way can the state control them, subjugate them, bring them into the state legal system, right? So state recognition of non-state normative orderings never entails a wholesale, a full unconditional acceptance of these systems. They almost always go with conditions, with exceptions. Think of the repugnancy clause during the colonial period. So it's partial, it's conditional, and it's meant to make the customary, the local, governable for the state and in line with certain normative values of the state. Now, I don't know how many of you are from Aceh, but I was just reading the abstract of the beautiful thesis written by Arfan Shah about Gayo. And he actually comes to this interesting conclusion that state recognition of Adat law as part of the state legal system actually led to a high degree of autonomy, a higher degree of autonomy of these Adat institutions, which really goes a little bit against what I'm saying here and what the common literature says. So just reading the abstract has convinced me that I need to read the whole of it and understand more. So maybe when you hear me say this, you're like, oh, I'm not sure I agree. Well, I think Aceh is described as a different type of case of this. But normally, of course, recognition gives power to the recognizer, right? So we need to understand these in different contexts. And you can imagine that a context such as Australia with continued colonization, severe marginalization, these questions of regulation and state recognition and the power of the state over the local are very different than, for instance, in the country of Ghana, where everyone and no one is indigenous, where no one's really fighting for autonomy from the state, where customary law also is already much changed due to contact with state law and the economic system. And also importantly, where indigeneity or traditional communities are not much related to marginality. So what we need to remember is state recognition sounds positive, right? It sounds like, hey, you know, finally recognition, finally acceptance of what's out there locally. But it places power with the recognizer. And it goes with restrictions and it goes with incorporation. So the other gets to be incorporated in the state system, into the system and the logic of state law to a large extent. And that means that the local, to get that recognition, often needs to accept the type of legal system or the underlying relationship, for instance, between people and earth that is part of that state legal system. It also means possibly having to prove to be a traditional community, or it may be receiving recognition of certain rights, but only as long as these are exercised in a traditional way. There's an interesting case of Canada where a First Nations community was indeed granted its fishing rights, except only as long as they would fish with traditional gear. So they couldn't go out with a trawler like anyone else who's now trying to make a living off fishing. No, their rights were only recognized if they continue to do it the traditional way. Okay, so this slide, which was already up a minute ago. So we've now been talking about struggles between the local community and the state, right? Or powerful third parties, think multinational companies. But this is also very much connected to relations within the community, at the community level, and questions of how government recognition or government involvement in the local impacts on such local power relations. So thinking of checks and balances, right? Or thinking of layered decision making, which is very common in customer justice systems, right? You go to the lowest level, and only if you can't fix it at that level, you go one level up, and only if it deals with, I don't know, many people or a bigger area, you might go up to another level of decision making or dispute settlement. But is that recognized by the state, or does the state rather see only that highest level as the spokesperson with the state or as someone who has decision-making power? This is exactly what legislation in South Africa is now doing, saying that the senior traditional leader can determine everything for all, let's say, 35 villages under it. So who does the government see as representing a community, as decision-making institutions or decision-making power, having decision-making power on behalf of the community? And lastly, also, is there an opt-out? This again is a case that was really prominent in South Africa. In South Africa, they were working on a traditional courts bill, which was strengthening the power of traditional courts and their summoning powers and their sanctioning powers. But one big discussion was around, what if someone doesn't like that system or wants to opt out and say, I'd rather go to a state court, right? What if women feel state law and state courts are more positive than traditional courts and traditional law? Can they opt out? And this was very much discussed around an infringement of citizenship rights. Can you tell these women, just for living in these former homelands, that they can't take a case to a state court unless they've been through 3 levels of traditional courts, which many people find already impossible in sense of access and pay and time, etc. So this was really an issue of, is it empowering to strengthen these customary justice systems and these tribal courts? Or is it disempowering and infringing on individual people's citizenship rights because now they have different rights? I was thinking of the citizen and subject, this distinction that Mamdani talks about. Do we have citizens for those who live outside of the former homelands, but are the ones inside still more subject to a chief? And my last point for this presentation goes back to why I decided to take these 4 cases, 4 case studies, 4 countries, is that context obviously really matters, right? Is the traditional community a marginalized group? Is it a minority, or is the majority of the country made up of traditional community? If it's a minority, has there been a process of decolonization, or is there still really something that needs to happen? If we look at Australia and Canada, for instance, we see that there are strong appeals, both from community members, Indigenous community members, but also from academics, that we need to take Indigenous law seriously, that we need to put them center stage, that we need to put Indigenous law center stage. And that, for instance, for Australia, that would mean accepting Indigenous people's different conception of this relationship between people and land. So not forcing them into the state model of law and land relations, but accepting their own model. Now, that example, in a way, is easy to accept, right? In a way, I think we can all agree that we're busy killing the earth, and probably it would be better to treat the earth the way these indigenous groups in Australia are. So in a way, if we say we need to take that seriously, we need to accept that there might not be too many people arguing against it, except of course people that talk from the side of the state and from making land marketable and talking from the economy. But what if we can complicate this for you? If we talk about putting Indigenous law center stage, and we're not talking about, a relationship between law and earth, or between people and earth, as in Australia, but what if we're talking about, let me give you an example of Pakistan, where girls and women, but particularly girls, can be heavily punished under the tribal justice system if their male family members, like a brother, have committed a crime in the sense of been with the wrong woman or looked at the wrong woman, etc. Right? So what if what the customary justice does goes clearly against what the indigenous justice believes in and stands for, goes clearly against what these countries also seem to protect in their constitutions and in human rights, right? Can we then still say that, well, we just should put indigenous law center stage? And if we do say that for some cases, but not for others, then what is that distinction based on? And who can make that distinction? And on what basis? Is the basis then individual human rights, gender equality, constitutional rights? Or, could we say the same thing, that perpetuates Western, maybe post-colonial impositions on indigenous groups? So I'm just adding this example because I think it's easy to sort of accept that the indigenous groups in Australia will to accept their indigenous understanding. But in other cases, it will be much harder and posing very different questions. And that then poses the question, who decides on when, yes, we do put it center stage and when we do not? What's the benchmark for that? Okay, thank you for this. I think I'll stop sharing now.
Okay, thank you, Prof. Janine. Thank you very much for providing such a comprehensive and multi-layered perspective on legal pluralism, bringing the global, national, and local dimension. Your insight on how the state and non-state legal system coexist and interact, how deepness or outstanding of the complex realities of law governance and community relation. This presentation truly enriched our appreciation of how indigenous, customary, and state legal orders shape justice practice across different societies, inspiring us to rethink the future of law, recognition, and inclusion within plural legal framework. Ladies and gentlemen, we will now open the floor for the Q&A session. This is an opportunity to engage directly with Prof. Janine, whether to seek clarification, share reflection, or draw comprehensive thought from your own context. If you have a question, please raise your hand or use your raise hand in your features or type your question in the chat box. Kindly introduce yourself before you speaking. Okay, here, 344. Okay, who's the first one to give the question? Okay. Please introduce yourself.
Okay, am I audible? Okay, first I want to say thank you for having me, and I would like to introduce about myself. I'm Selinda, and I'm a law student. So, I would like to ask you a questions that Professor Janen. So the question will be, at first I want to say thank you for your insightful PowerPoints, your insightful presentation. So, you describe how the recognition of native title remains rooted in colonial legal frameworks. So, in that case, in Suriname, despite several international rulings affirming indigenous lands right, the state still follows legal frameworks rooted in colonial traditions, by the way. What do you think? Like, what is your opinion prevents post-colonial governments from breaking away from these colonial patterns and creating a system that genuinely reflects indigenous conceptions of land and authority? Thank you very much.
Okay.
Do you want me to answer, or are we doing a few questions first?
We continue question, Prof.
Yes, please.
Thank you for the time. My name is Adi Subaja, and I'm from Faculty of Law, University MICoLLS. In here, Prof, I just want to ask one simple question. If state recognition of customary law always give power to the party that recognizes, does the legal pluralism to recreate justice, or it just simply perfect a new form of state domination over indigenous people? Thank you for that.
Okay, thank you for the opportunity that be given to me. My name is Nazwa. I'm a law student, and I want to ask about legal pluralism, of course. Especially in Indonesia, decentralization has often been presented as a way to empower local governments and recognize diverse social and legal realities, the local wisdom itself, or we call it as adat systems. However, in practice, local authorities often remain tightly bound by national regulation and political interests. So the question is, has decentralization truly strengthened genuine legal pluralism, or has it merely created local version of state control? Thank you. Next question.
Okay, thank you for this opportunity. My name is Safa Amira Putrulubis. We'll talk about Ghana, South Africa, and so on. And I'm a little curious about the Netherlands itself have legal pluralism that causes a clash between it and how the result of these classes. Thank you.
Okay, thank you for all the question. Now, I would like to invite Prof. Janin to kindly respond to the question.
Yes, thank you for all these questions, and they all center around these same themes, right? So, I think what I was trying to tell you and what you're picking up on is recognizing something, right, in a way is positive, but it gives power to the recognizer. Now you can do that in a huge number of ways, right? Where, I mean, some countries recognize customary law just by saying, we recognize customary law as a source of law and we recognize traditional authority. And that's it. And they actually recognize customary marriages, customary land, all of that. And they have very little defined. And so it's all about how much does the state define, then in what way, and which institutions have a say, and how heavily do they interfere in it, right? So that can really lead to a whole variety of ways of doing it. Where, of course, the struggle in Australia, for instance, isn't just is in a way so hard because these communities have such completely different ideas of this, right? If there hasn't been any decolonization, if these indigenous communities are so heavily marginalized, and they're not really a part of the system and not really a part of the state and of the larger community in the state, then you can wonder to what extent a government and a state is willing to take the step of actually recognizing what is out there, right? I mean, the recognition is always restricted, right? What kind of land rights do we give back? Well, to communities that can still prove they're traditional and that still have those links to the land. So everything that's lost earlier, when colonization in a way was more successful, you can't even make a claim anymore, right? So it's already only about what remains. It's never really about reparation or going back to what was stolen. Which isn't so much the case in Ghana because everyone's indigenous, but in South Africa, in Suriname, well, not so much in Suriname, but South Africa and Australia, that's really the case. So, to what extent does it really bring empowerment or a perpetuation of domination? Well, depending on the specifics, it's a gliding scale from recognition in name, but it doesn't do much, to recognition, which is quite empowering. And that really depends on a number of steps and approaches. So that's exactly the variety I was hoping to show you. So if you're asking this question, I think I partly succeeded. The question from Celinda was, what prevents governments to break away from colonial conceptions? Well, I think largely economic opportunities, right? Most of these fights are about natural resources. Australia, one of its main incomes is mining. Suriname, bauxite earlier, and now gold and logging. So it's all about these natural resources. South Africa, the big issues are around platinum mining and oil mining. So definitely economic, not willing to have that with a community that either doesn't exploit it or personally gets rich, or as a community, but not the country. But I also think it's the dominance of the Western legal system. We, the West, I'm putting my hand in my own pocket here, but we have been so successful in getting that legal system, that state legal system, into the rest of the world, and most of the world doesn't see an alternative anymore either, right? I mean, I see very few post-colonial countries who do away with it and go back to a local only system. So I think only quite recently we are hearing these pleas from even Western scholars saying we need to take the local and indigenous serious, and it takes a lot of decolonization of the mind as well. These are such strong, taken for granted system, both the economy, right? What's good for your country? Everything that exploits. I mean, you can look very differently at the relationship between earth and people, right? Like the indigenous people in Australia do, but that's not our common way, and it's not the way of the powerful. The same for our legal system. So I do think it has to do with dominant structures and dominant styles of thinking as well. Last question was about the Netherlands. A lot of the legal systems in Europe, for instance, used to have custom, right? Custom was one of the sources, but at some point, this usually got incorporated into the state, and at that point, it got codified. And that meant two things. It meant that lawyers now sort of became the developers instead of people, right? It also meant that it became less flexible because it's not lived, but it's on paper. And that again means there's often a gap between what's happening in practice and what's happening on paper. And in communities where the paper and the state is relatively weak or has little outreach, or where the paper originally comes from a foreign invader, etc., you see that that local remains strong and that the customary remains. In the Netherlands, you can't say we have living customary law anymore. Nevertheless, the idea now is that we see legal pluralism everywhere, right? If we have a strong religious group here, there's legal pluralism because they will have their own norms that, in the sense of the semi-autonomous social field of Sally Folk Moore, where people make their own rules but enforce their rules, right? Not through the state and not through courts or dispute settlers, but in the sense that you don't belong anymore if you're not following these rules, or you're not seen as a moral person in your community, which hurts and is difficult. So there's legal pluralism definitely in the Netherlands, but not so much in the sense of, I don't think anyone will say, oh no, but this is according to my custom. They might just say, I believe this. It's more social norms than customs. But customary law has really been taken up in all the statutory law or all the state law, and still a lot of interpretation of legal principles is, for instance, based on the common understanding or the reasonable man. And of course, that goes back to customary behavior, right? So there's still custom there. I hope that answers your questions a little bit.
Okay, thank you very much, Prof. Jenin, for your insightful and thought-provoking response and for sharing such valuable perspective with us. Your presentation and reflection have truly deepened our understanding of legal pluralism, especially about legal recognition for indigenous people across various cultural and institutional contexts. Thank you once again, Prof. Jenin, for being with us today. It has been. Oh, question? You add the question? No. Prof. Jenin, how about if we add some question? Question from the audience here or the online audience? You can chat in the box, in the chat. Oh, okay.
Oh, thank you, moderator. Hello, Miss Jenny Ubing. Let me introduce myself. My name is Nanda Sita Saputra. I'm from Faculty of Law, MICoLLS University. So, Miss Jenny Ubing, my question is, in today's globalist legal landscape, do you see legal pluralism as a way to press local identity or as an obstacle to national and international legal integration? Thank you.
Next question.
biar nggak capek-capek, Bu. Okay, the last question. Let me introduce myself. My name is Halsingki Mutyagama, and I'm student of Faculty of Law, MICoLLS University. So, I have saw in your PPT about the theory of legal pluralism reject dualism. But if the theory of legal pluralism reject dualism and described complex interaction, but I see in reality in Indonesia, such as in Papua, the state actually acts in dualistic manner. Doesn't not this show that the theory is idealistic, while in practice, the state has the power to choose when it will recognize customary law and when it will ignore. It's for the sake of national interest, shows us development and on customary land. So I feel that states' sovereignty ultimately remains the highest law that is able to subdue other legal system. Thank you.
Okay, we have the last question.
There's one in the chat, I
Who's
think.
online? Oh, online.
Oh no, that just says
Oh, no.
thank you or something, I think.
There is no question from online. Yeah, now maybe I would like to invite you, Prof. Janine, to kindly respond to the question.
Sure. Pluralism as a way to preserve local identity or an obstacle to national integration. I think it can be both, and it's really again just about how it plays out. I think in many countries post-colonial, so right after independence, it was very much seen as something of that would hinder nation building, state building, something of the division that the divide and rule of colonial government had played upon. So really at that time it was seen as not fitting a nation state, also against modernization where we needed, clear rights to land and property so that we could, have development. That all of that, of course, is against those dominant frameworks, right? How is your country going to grow? What kind of economic system? What kind of legal system do we need for that? And all of these are heavily pushed, right, by World Bank, IMF, who only give, lend money to countries that are in debt, particularly in Africa, right? This is a big thing. If they structure their economy in this way and open it up and do away with the customary law. So that was really the first idea. What did they find out 2, 3 decades later? Customary law isn't going away. Traditional leadership and traditional legitimacy isn't going away. And in many countries, and that links to what the second person said, the state has the power to choose whether it will recognize or ignore. Yeah, on paper, yeah, but it's an empirical question how much impact that has, right? If a state says, I don't recognize traditional authority, that doesn't mean they're gone. That doesn't mean that people don't go there if they have a question about their land or a fight with their neighbor or with their husband or so. I think that's what legal pluralism studies is trying to say, right? The legal construct, usually the state follows, is the state has the hegemony, the power to say which other legal norms it fits into its system. Sure, that doesn't determine, however, the empirical reality of where people, which normative orders people follow, right? And which leaders they follow and find legitimate and turn to. So really, I think it's an empirical question that, again, depends a lot per country and per context. And I think the reality is, and I think that might be a little bit different. I think in Indonesia, if you compare that to Ghana, where 80% of the land is customary, where almost everyone is a member of a customary community, that's a different story, right? If you there say we're going to not accept customary law or we're going to ignore it, what does that mean? If 80% of your people marry according to customary law, what does it do if as a state you don't recognize that? Or if you try to regulate it, one of the things they said is, okay, well, we have better governance power over this and also a better way to protect people if we know which customary marriages have been done. So what they said at some point in Ghana, for instance, and in several other African countries was you it's okay to marry according to customary law, but then you need to register. And as soon as you register, then the state recognizes your customary marriage. The impact wasn't that women particularly got better protected, because the impact actually was that men now refuse to register. So instead of just recognizing the customary marriages, because of that extra step that was supposed to bring protection, it's actually bringing insecurity for the group you're trying to protect. So if your reality is one of legal pluralism, but your legal system doesn't recognize it, that also leaves a whole open field of questions of who can profit from that. And usually it's the powerful, right? So this whole story, of course, was about power, right? Power of the government over the local, which really is an empirical question, how much power they have and how much power they're willing to give away, maybe. But also power relations and opportunities from legal pluralism, from legal pluralism, from various normative orders, from various institutions out there within the community. Who can benefit from them? That who cannot? Who's hurt by it? Who loses out? I think I'll leave it at that.
Okay, thank you, Prof. Jenin. Actually, I have a question to you. Uh, uh, but before I asking my question, and no, you have, if you have, you start first.
Di sini ya. Okay, thank you very much for the opportunity. Ibu Janin, very nice to meet you. Yes, we already heard about your experience in Ghana, Suriname, Australia, and also South Africa. I think the legal pluralism happened there. It's also happened here in Indonesia, especially when talking about customary land. I agree with your opinion that when it when about economy, and then usually Indonesia doesn't, we recognize the hak ulayat, we call it hak ulayat, but only on regulation. But when in reality, in empirical, many people who own the customary land, if we also have a regulation, if there is what we say a state interest there, and then the customary right, it can be not belong to the people of adat anymore. So yes, it happens when when it touch the economy, and then the people, we say masyarakat adat here, the local people doesn't have right anymore. I would like to know your opinion, based on your experience. Is there any hope for the people to get back their right, especially in customary land right? Thank you very much.
Actually, my question has represent from Miss Leila question. Yeah. Please, Prof. Jenin, to answer that question.
So the question is for people in Indonesia, in masyarakat adat, in adat communities, who've already lost their land, to get that land back, right? That's the big question, of course. I think there's a lot more possible when you still have the land and it might be, something is coming in, there's a dispute coming now, you're making a claim on land that isn't too valuable. All of that is, of course, 10 times easier than first losing the land and then coming back on, right? And everyone knows this. So the government knows this, companies know this, and this is also why they try to, in some cases, make it happen, even though they're not sure they have these rights, right? Or whether the indigenous community should be protected or their land rights should be protected. Because once that mine is there, who's going to change it? So I'm quite negative or pessimistic about claiming back land rights that that communities have lost. I think if we look at, for instance, I think we see a real change of Western countries dealing with their own indigenous populations, particularly in Canada, Australia is starting. I think we actually see a change. I mean, at least we've gone from terra nullius to native title, right? But that is to lands that they have continued relations with, not to lands that they already lost and are no longer on. I think once it lost, I mean, I think you're already fighting a hard battle that is to be fought within the system, within the understandings, within understanding of truth and evidence and everything of the state, right? But I think doing that for parts that have been lost earlier for most countries would just be economically unacceptable. And of course, it does bring big questions also for people who have been on those lands, maybe also for 3 generations or I don't know how long, right? We tend to think it in a little bit of simple terms, like, well, it's a big company, they can, either pay better compensation or go somewhere else. But it's also, of course, just people living there, neighborhoods having been built, etc. So then it's one person against another. So I'm pessimistic, but I don't know. I hear it from Follow Institute. I hear a lot of Indonesia research passing by, but none of that. I mean, my own work is all on Africa, so I don't know the local specifics. My impression of the whole use of indigenous peoples and ILO Convention 169 is that where it used to be hard to get your Adat land rights recognized, now that will follow from being recognized as a Musyarakat Adat, but it's just as hard to get recognized as Musyarakat Adat. So it doesn't seem to have made it any easier. And some of the recognition seems to be tokenistic, right? Sure, if you're really a traditional community, we recognize it. But now to be a traditional community, you have to be really traditional and show me that you still do this the traditional way and you still do that the traditional way. And so if you've moved on, you lose your land claim, right? If you've been modernized as well in those 1, 2 centuries, it's an interesting state point, right? Standpoint.
Thank you, Prof. Janin, for your valuable perspective with us.
Thank you very much for having me here and for organizing this and for inviting me for this lecture.
Yeah, thank you once again, Prof. Janin, for being with us today. It has been an honor to have you at the fifth MICoLLS. We wish you all the best and look forward to future collaboration with Leiden University, maybe.
Thank you very much. Thank you, everyone. Bye.
Yeah, bye. Pardon me, to all participant, online participant and on-site participant, we take a break for a while to pray Asar for Asar prayer. And we will come back again to continue our session with the last speaker, Prof. Anthony Sidiala from South Africa at 4 p.m. Thank you. Ladies and gentlemen, welcome back after our short break. I hope everyone had a refreshing pauses already to continue our inspiring discussion this afternoon. I think here Prof. Anthony Diala already with us in Zoom meeting. Prof. Anthony?
Yes, I'm here.
Yeah, thank you, Prof. We have now arrived at the final keynote session of today's forum at the 5th MICoLLS 2025, a session that will bring our exploration of legal pluralism to a meaningful conclusion. Our last keynote speaker is already joined with us. Our final keynote speaker is Prof. Anthony C. Diala from South Africa. I would like to introduce our last keynote speaker for today. Prof. Anthony is leading authority on legal pluralism and currently serves as a director of the Center for Legal Integration of Africa in the University of Western Cape, South Africa. His scholarly work has significantly advanced global understanding on how customary, religious, and state legal systems interact, particularly within the Global South. Beyond academic, Prof. Anthony has contributed to international legal development through his role in editorial leadership and advisory boards, as well as his engagement with various institutions on law reform and human rights. As we move toward to the concluding perspective of today's forum, we are honored to your insight, Prof, on how diverse legal tradition can be harmonized in complex societal contexts. Today, Prof. Anthony will present the topic that discuss about legal pluralism and harmonization of customary, religious, and state laws in a global South context. Prof. Anthony, the screen is yours.
Okay, thank you very much. Can you confirm that I'm audible, please? Can you hear me? Can you confirm?
You can start your presentation.
All right. Thank you very much. And good morning, everyone. Good afternoon, wherever you may be. We are still in the morning here in South Africa. So it's a great honor and pleasure to be able to speak at the 5th International Conference on Legal Studies and Social Sciences. So I thank the organizers for inviting me, and I'm going to speak on legal pluralism and harmonization of customary, religious, and state laws in a global South context. So I'll be drawing examples from not just from South Africa, but also from West Africa, from East Africa, and from time to time, maybe also from Indonesia. Right, so let's start then. I need to find a way to show a slideshow here. 1 minute. I'm going to start with an overview of legal pluralism in the Global South. By overview, what I mean is a sort of historical background. I understand that the history of colonialism is quite extensive, but I'm going to shorten it as much as possible, just to show you how we arrived at the situation we call legal pluralism today. Now, certain European nations, specifically Western Europe, because it's not all of Europe that is responsible for colonialism in the Global South. Western European nations, the ones there on the screen, colonized this part of the world. For Indonesia, it's Netherlands. One key result of their colonization is what we call legal transplants, the imposition of their legal culture on the peoples of the Global South. So that's what the Europeans did, and it's the most significant event in the history of laws in the Global South. So when we speak about how laws interact, we're actually speaking about how they are regulated by the imposed laws. So the Europeans, when they transplanted their laws, the laws that they transplanted began to dominate and began to regulate the indigenous laws of the colonies. But that's not the most important thing that colonialism did. colonialism entrenched what we call Western knowledge hegemony. So this supremacy, dominance of Western knowledge. Western knowledge is used as the legitimating tool, the criterion for assessing the validity of other knowledge systems. As I will show later in this presentation, it's problematic. So these Europeans transplanted their legal systems, and these legal systems began to coexist with our indigenous laws. In Indonesia, we refer to that as adat law. In other parts of the world, we refer to them as customary laws or indigenous laws. This coexistence also goes on side by side with religious laws, mostly Islamic Sharia laws. So these all constitute what we call today as legal pluralism. So legal pluralism is just the fancy name that academics came up with to describe how laws interact in the global south. But this interaction of laws causes a certain kind of problem that we know today as conflict of laws. I describe it as problematic legal pluralism. And the reason is very simple. There is what I call a dissonance, a tension, discord, difference between the social origins from which indigenous laws emerged and the origins from which the European imposed laws emerged. So these European laws came out from what we call industrial settings. As at the time that Europe was colonizing most parts of Asia and Africa, they had entered the second industrial revolution. But Africans were still in the agrarian phase, the agricultural phase. So the Europeans came and transplanted laws that prioritized capitalism, profit, and the individual. So the laws that they imposed had an industrial flavor, whereas the laws that Africans and other parts of the world, the Asians, were applying were laws that focused on the welfare of the group. The interesting thing about colonial imposition is that the laws that were imposed eventually became what we know today as statutory laws or state laws. So like I said, these laws are centered on three elements: on capitalism or profit. They are centered on precedents, rule-making, rigid rules that are predictable and ascertainable. And then they also focus on the welfare of the individual rather than the welfare of the group or the clan. Another important feature of the imposed laws is that they were accompanied by new values. So when we speak about colonialism, sometimes we tend to neglect what came with colonialism. European colonialism, as far as law is concerned, is not centered only on imposed laws. We also have to look at the type of changes like new religion, the new technology that the Europeans brought. We have to look at their forms of education. We have to look at the work systems that the Europeans brought with them. All of these had the effect of turning the colonial subjects into the normative image of Europeans. So as far as behavior is concerned, colonialism had the effect of turning its subjects into the mirror of the colonizers. And it's a problem for the interaction of laws today, as I proceed to show. So the indigenous laws, the adat laws, the customary laws of the Indonesians, the Africans, and the other Asians, these laws focused on group or clan welfare, the welfare of the extended family, unlike the laws that the Europeans brought. But today, these customary laws are heavily regulated with universalist values of proper behavior. So what do we mean by these universalist values of proper behavior? Usually, post-colonial states adopted constitutions with bills of rights. So these bills of rights contain what are called universal human rights. The interesting thing is that these universal human rights, most of them are based on the Universal Declaration on Human Rights. We know that document was adopted on the 10th of December, 1948. Now, the interesting thing is that when that document was proclaimed by the nations of the world, in quote, most of the global south, over 90% of the global south, were still under European colonialism. So you see these Europeans coming out and proclaiming freedoms for the whole world, universal freedoms, whereas they still had people in bondage, people that they kept under colonialism. So when post-colonial states adopted these bills of rights, they centered them on three key rights: rights to equality, to human dignity, and to non-discrimination. If we look at Article 18B2 of the Indonesian Constitution, it stipulates the conditions of legal pluralism by showing the conditions in which adult law would be recognized. So in most cases, most often in practice, what happens is that adult law, customary law, indigenous laws, they apply only subject to constitutional values, subject to the values of the post-colonial state, which itself is molded or crafted or formed on the basis of European culture. So that's what happens with legal pluralism. This is what makes legal pluralism problematic. And if we should go back to the topic of harmonizing these disparate legal orders, we must bear it in mind that adult laws, indigenous laws, or customary laws, they are heavily regulated by these colonially imposed substructure. So any framework that we come up with for the harmonization of laws must recognize this reality, that indigenous laws are not on the same level with statutory laws. They are inferior. We see examples of it in what happened in a case that I gave an example. 2017, the Constitutional Court of Indonesia invalidated a law number 13 of 2012, that applied in the special region of Yogyakarta for violating equality and non-discrimination. So basically, the law hinted that for you to succeed to a certain position, then you must be married. And so it gives the impression that you must be male that is married, and thereby indirectly excluding women from succeeding to that type of position. So the Constitutional Court invalidated it for non-conformity with the values in the Constitution. This practice of subjecting indigenous laws or subjecting adult laws to state regulation, to constitutional values, I call it jurispatic regulation. Jurispatic regulation is very crucial because it requires indigenous laws to be living law. So for law to be recognized in Indonesia, it has to be living law that conforms with societal development, that is consistent with the principles of the Indonesian state. It's similar to what we have in other parts of Asia and in African states. In South Africa, for law to be recognized, indigenous law to be recognized, it must conform with constitutional values of equality, human dignity, and non-discrimination. In other African countries like Nigeria, like in Ghana, they require indigenous laws not to do what? To contravene the repugnancy test, repugnancy clause. So it must have what? Respect for certain principles of natural justice, equity, and good conscience. All of these are determined according to Eurocentric notions of proper behavior. So in essence then, in summary, the regulation of indigenous laws operates on a Eurocentric basis, on the basis that the imposed colonial laws are better than the indigenous laws. So in many parts of the world, colonial judges used the criterion that we call repugnancy test. It insists that a custom must not offend principles of natural justice, equity, good conscience, whatever these things mean. So post-colonial judges eventually replaced this repugnancy test with constitutional bills of rights. So as I have been saying, these constitutional bills of rights center on three elements: human dignity, equality, and non-discrimination. But one key thing remains unchanged. The philosophy of regulation, the idea of regulating indigenous laws remain the same. And that idea is that the colonially imposed culture, the colonially imposed laws are superior to indigenous laws. They are superior to adult laws. So that's what happens, especially at the appellate courts. At the lower courts, they try to privilege adult law as much as possible. But when it goes on appeal to the Supreme Court, to the Constitutional Court, then those judges usually use the criteria, the constitutional principles of human dignity, equality, and non-discrimination is what prevails ultimately. Right. The argument then is that this so-called jurispatic regulation of indigenous laws, that it hinders, it is not good for meaningful legal harmonization. And the reason why I make this claim is very simple. Legal history has shown us that wherever post-colonial societies did not take conscious steps to preserve the core values of their indigenous laws, these laws eventually disappeared and they were replaced by the colonially imposed laws. So I have tried to, in my works, to critique what we understand as customary laws, especially the living component of customary laws. In this seminal article, I tried to show that what we call living customary law is actually how people react to the socio-economic changes brought by European colonialism. I always tell my students that whenever we speak of colonialism, we must think of colonialism as sort of frontline troops. Colonialism is the vanguard of globalization. So think of colonialism as the commandos, those who go in and kick down the door, you know, and before the other regular infantry will then come in. So colonialism paved the way for the globalization we know today, what we understand today as globalization. It was spearheaded by colonialism, because what does colonialism do? It brings disparate societies together and forces them into nationhood. So unity, that's what colonialism sought. Bringing disparate tribes, people speaking different languages, and calling them one name, Indonesia, calling them one name, South Africa, one name, Nigeria. That's unity. Forced amalgamation is what colonialism sought to achieve. So in that sense, colonialism is the vanguard, the poster face of globalization. In other words, I have tried to argue that we must, if we are serious about legal harmonization, we must look at the true identity of indigenous laws. So global South countries need to come together and realize that sometimes what they present as customary is not customary, that it's the product of influence from colonial contact. And so there I use the example of customary courts in Nigeria by showing that these courts are not really customary. They are not indigenous. These are anglicized courts, courts that operate according to English procedure, according to colonially imposed standards and philosophies. Then in the South African context, I have shown that the regulation of customary laws in South Africa is jurispatic and will eventually lead to the disappearance of these customary laws. I expressed it in the title of that article, that our laws, in other words, our colonially imposed laws, which now masquerade, pretend to be statutory laws, that they are better than indigenous laws. So that's the feature of legal pluralism in South Africa. And I dare say that that is also the feature of legal pluralism in most parts of the global South, and to an extent, Indonesia also. So I have tried to show that feature in the context of personal family laws in Africa, by showing how law reforms, both in the judiciary and in parliament, has this effect of constructing indigenous behavior into the image of acceptable European conduct. So that's what we see in law reforms in the global South. And to cap it off, I edited a volume in which the argument we made is that we must reimagine legal pluralism. If we are serious about legal harmonization, we must find a way of balancing the coexistence of indigenous laws with statutory laws and religious laws on the continent. So then that brings me to the types of legal orders that I have identified in the global South based on field work that I conducted in several countries. So the first type of legal order is the one I have been speaking about, the statutory laws. So these are the European laws and their adaptations, which were imposed on post-colonial societies, imposed on global South states, and passed off as legal transplants. I always have a problem when people refer to
colonially imposed laws as received English law, or received Dutch law, or received civil law, or received Roman law. That is wrong. It's not received per se, it's imposed. It's not like the Europeans came and say, hey guys, we want to colonize you. Are you happy for us to rule over you? No. Sometimes colonialism was accompanied by bloodshed, by force. And so the indigenous peoples did not have much choice in accepting these laws from Europe. These laws then eventually changed form and they became codified and they became statutory laws. The second category of laws is what I refer to as indigenous laws. These are pre-colonial norms that developed in agricultural societies, in communal societies that aimed at promoting the welfare of the clan. So these pre-colonial norms are still observed in their ancient forms. A very key example is patriarchy, founded on male primogeniture. So today, when society or gender activists or civil society groups, when they condemn patriarchy and when they condemn male primogeniture, they forget one thing, that male primogeniture was ideal. It suited the societies in which pre-colonial global South states lived. In those type of societies, the primary needs were defense and agriculture. So people hunted in groups, they farmed in groups, and there was need for an authority figure, a central figure, to defend the family from threats, both external and internal. This central figure performed three key roles. He performed a military role because he organized the young men of the family, of the community, as warriors. He performed a spiritual role as someone who interceded between the ancestral world and the spiritual world. Mind you, this was long before Christianity or even Islam came. And then finally, he also performed a political role. So he organized the family, made sure that everyone was taken care of. He, of course, inherited property on behalf of the family. So he used it to ensure that everyone was taken care of. The mere fact that he was the one inheriting property did not mean it belonged to him. He was like a trustee, using it for the benefit of the family. So this worked well in societies where income production was group-based rather than individual, where activities were based on the group, and where there was a strong link between the spiritual world and the physical world. But when colonialism came and introduced urban migration, civil service work, and all the other changes that it brought in the lives of people of the global South, things, of course, changed. Male primogeniture became unsuitable. Remember that the laws that were transplanted came from industrial societies. And so when they were imposed on people in agricultural settings, problems arose. That's why gender equality today is a cardinal principle, and it's contrary to male primogeniture. So when we speak of legal harmonization, we must bear in mind this difference between the origins of ADAT laws, indigenous laws, and our modern individualistic conditions. The final category of laws is what I call customary laws. So you see now, one might be confused in thinking that I have a category called indigenous laws and then another category called customary laws. There should be no confusion here. The reason is very simple. Whenever indigenous laws encounter the socio-economic changes brought by European colonialism, they do not remain unaffected. They change, they adapt towards those socio-economic changes. And the product of that adaptation is customary laws. So customary laws then may be defined as hybrid laws that emerge from people's adaptation of their indigenous behavior to the socio-economic changes of colonialism and now globalization. That's how I perceive customary laws. And an important element of this definition is that when we speak of legal harmonization, then we are looking at this third category. That's what we are looking at, customary laws. We are not looking at the second category of indigenous laws because most of them have disappeared. So legal harmonization must involve customary laws and statutory laws. And for us to do this, we need a certain way of thinking. we need a certain way of a theoretical approach, so to speak. But before I get to that theoretical approach, I must issue one or two warnings. The first one is that any effort at harmonizing legal orders in the Global South should recognize the concept of coloniality. Now, what is coloniality? I define it as persistent patterns of power and philosophy left behind by European colonialism. Think of it like this: the king is dead, long live the king. So colonialism, European colonialism formally ended, but it did not really end. It merely changed its form. So the post-colonial subjects behave exactly as their colonial masters, in much the same way as the animals, the pigs, became like their human masters in George Orwell's 1984 classic novel, Animal Farm. For those of you who have read that novel, you will see how gradually the animals became like their human masters and began to oppress their fellow animals the same way that the humans did. So coloniality then describes the condition of colonialism in which the structures put in place by colonialism continue almost unchanged after colonialism ended. So harmonizing legal orders in the Global South should recognize this phenomenon, this problem of coloniality. Secondly, it should be able to find a way to handle the conflicts that arise between human rights and indigenous laws. And like I said, this conflict centers on the dissonance, the variance, the difference between the social origins of indigenous laws and the social origins or industrial origins of statutory laws. Then finally, any meaningful attempt at harmonizing legal orders in the Global South should stop the Eurespathic policies that are currently in place. The way statutory laws or state laws construct indigenous behavior into the image, into Eurocentric human rights values must be stopped. It's going to be a big problem, a big challenge, but I think with concerted effort, it can be done. So then the question becomes, how should we approach legal harmonization? What should be done? What sort of thinking do we require for us to carry out meaningful legal harmonization? Then enter what I call adaptive legal pluralism. Now, I want to show something from here. Just 1 minute. I wish I was in a physical audience. I would have taken a quick poll to ask how many people have heard this anthem before. Now, this anthem is played in many graduation ceremonies across the world. Many graduation ceremonies. It's originally something that came from a Latin student song in 19th century German universities. But today, most universities across the world, whenever they are doing graduation, they play this anthem. Now, look at that picture on the screen. These are students from the University of Zululand.
Sorry, because I'm interrupting you, Prof. Anthony, because your slide is, your screen is stuck.
My screen is stuck?
Yeah.
Oh, okay. What is showing there now?
Just your, yeah. Yeah, only your title, your first slide, only your first slide.
Has it been the first slide all this while or just now?
Yeah.
Only just now, or has it always been the first slide since I have been speaking?
Yeah.
Why did you not tell me all this while?
I'm sorry. Yeah, because we already have your slide. Oh, yeah. Okay. Thank you, Prof. You can continue the presentation.
Well, no, this is now disappointing. I mean, all the things I have been saying since you haven't been seeing the slides. All right. So I played a song from what we call the graduation anthem. I don't know if I should play it again. Should I play it again? Not really. Right. So it's called the graduation anthem. If you go on YouTube, you will find it. So I was saying that it's played all over the world in many universities during graduation. And there on the screen, you will see students from the University of Zululand in South Africa. You can see the flags that they are carrying, the South African flags and all that. You can see their attire, what they are wearing. So you can see that they are dressed in native attire, dressed in native clothes, but they are celebrating a European song. So that presents a powerful lesson for legal harmonization. And that lesson is very simple, that post-colonial subjects, communities in the global south, what they do is to adapt towards the laws and the cultures imposed by the Europeans. So they adapt towards them and they blend them with their own indigenous laws to produce a new product, a hybrid product that we refer to today as customary law. So now it's customary in South African universities to play the graduation anthem. And now universities must find ways of blending it with their own native customs. Some beat drums afterwards or do other things that bring in that indigenous element. But the point I'm making is that for us to carry out successful legal harmonization, we need a philosophy. We need a theoretical framework. And I have articulated one, which I call adaptive legal pluralism. Now, what is adaptive legal pluralism? It is based on the idea that law adapts. A very interesting book by a sociologist, Donald Black, in 1976, it's called The Behavior of Law. So he argued that law varies in line with other aspects of social behavior, such as status, culture, control, and symbol. My argument is to take it further by saying that any law that behaves is also law that adapts. So behavioral law is adaptive law because when legal orders coexist under the shadow of globalization, the people who observe indigenous laws invariably are compelled to change their behavior, to adjust their behavior to socioeconomic changes. So then, the interaction of post-colonial laws is imitative. It also reflects the persistent patterns of power and philosophy brought by colonialism. So adaptive legal pluralism recognizes the power of coloniality and argues that legal harmonization should be based on how people adapt their behavior, their indigenous laws, to socioeconomic changes. And how do we do this? How can we successfully blend statutory laws with customary laws? I present the foundational values of indigenous laws as the basis for this blending process, this legal harmonization process. So now, what are these values? Foundational values are simply collective beliefs about right or wrong that people hold regarding their conduct. Now, in a general sense, values explain the nature of law. In fact, people struggle to define law, but with values, it's a very easy thing to define. Law should not be problematic at all in its definition. Whenever social behavior or habit meets a sense of obligation, the product is law. Very simple. Whenever habit merges with what? A sense of obligation, law is the result. Let me give an example. If you are in the habit of shopping from a particular shop, and then you decide that, okay, I'm tired of shopping here, I'm going to move to shop B, and then you start shopping at shop B. It shows that there is no sense of obligation accompanied, or no sense of obligation inherent in their conduct. But if there is a sense of obligation, and you want to move to a different shop, and the people around you say, no, you cannot move to that shop, then law is evident because it means that there is a core value that underpins you shopping from shop A rather than shop B. And when people exert pressure for you to conform, That sense of obligation gives your behavior the character of law. In this context, then, the foundational values of indigenous laws, they give us understanding of the type of social context in which indigenous customs emerged and why these customs sometimes clash with the Western human rights values in our contemporary era. The foundational values are too many for me to present in one particular session. Actually, they form the subject of my recent inaugural lecture in September. There are so many of them. What I'm going to do is just to list the most important ones, and then we move on. So they are marked by certain features of communality, features of spirituality, defense needs, group income, all of which characterize pre-colonial societies and the ways they lived. Right. I'm not going to go into detail in these ones, but I want to present the most important of these foundational values, and that is Ubuntu. Ubuntu simply means that a person is a person because of other persons. So your existence as a human being is linked on or hinged on the existence of other human beings. It's a cosmopolitan, holistic way of seeing the world. So you look at the world both in the past, the present, and the future. As exemplified by a Yoruba chief who told a committee of Europeans that the way he perceives land is that it is something that belongs to people from the past, people living now, and people who are yet to be born. So Ubuntu philosophy simply means that you must care for the welfare of the person around you, because we're all sisters and brothers eventually, more or less. It was the constitution of pre-colonial societies, and it helped the people of the past to be able to live in harmony with one another. So based on the foundational values of indigenous laws and based on the principle of adaptive legal pluralism, I have articulated 5 steps that I feel Global South states should follow if they are serious about legal harmonization. And the first step is to accept for the judges and parliamentarians or lawmakers to accept the influence of globalization on indigenous behavior. Once this acceptance is reached, then people will be able to see that they have acquired a new legal identity that is heavily influenced by European colonialism. The second step is to ascertain the foundational values of indigenous laws. And as this process is carried out, there should be more emphasis on what? On normative dialogue, on how legal orders speak to each other rather than against each other. And number 3 is to substitute constitutional bills of human rights with the foundational values of indigenous laws. Following from this, then, the next natural step is to carry out targeted law reforms, both from the bench, judiciary, and from parliament to align indigenous values with modernity. We have modern situations that are no longer compatible with some of the ways that people lived in pre-colonial societies. And so this recognition must be carried through in law reforms. For you to do this, of course, you must explain to traditional authorities the reason why the ancient ways of doing things are no longer suitable to modern conditions. And then finally, then we can merge customary laws with statutory laws using the core values of indigenous laws as the foundation. And in order to bring this to fruition, what I have been doing with my colleagues at the University of the Western Cape is that we founded this Center for Legal Integration in Africa. We founded it in 2020. Now we have a new unit that we established last year. It's called the Muslim Personal Law Unit. And what we do in this center is simply to probe how the interaction of legal systems affects the way people behave today and affects human rights. So we try to direct not just academic attention, but also policy attention to how the conflict of laws are caused by the imposition of foreign values, so to speak, and how we should move away from this conflict of laws perspective and rather focus on dialogue between African legal systems. So in a nutshell then, effective legal harmonization in the Global South needs to understand the history of European colonialism, the effect of European colonialism, and the power of coloniality. Once this is done, then we can move towards meaningful integration using these foundational values, like I said, as a basis. And then, of course, with proper legal education and civil society awareness, including to traditional leadership institutions, then we can make progress and eventually arrive at common laws in the Global South. And how do I know this will work? I know it from legal history. The legal history of the Global North shows us what happened. Let's just take one example from Great Britain. Great Britain, as we know it, or United Kingdom, they were colonized by the Romans for a period of about 400 years. 400 years is a long time. So the Romans imposed their own laws on the English people, and English customs were forced to adapt to the imposed laws. Eventually, the Scandinavians came, the Norman conquest of 1066. They came, also colonized the English people, and English customs again adapted. Eventually, the English common law emerged from this process of adapting to Roman laws and Scandinavian laws to produce the English common law. And then guess what? The English then went out and colonized other parts of the world and imposed the English common law on these parts of the world. United States of America, they imposed their laws there. Many parts of Africa and Asia, the British imposed their laws. The Dutch went out, Netherlands, and did the same thing. The Dutch themselves were also under Roman influence, and they imposed laws that had adapted to Roman law and became Roman Dutch law for South Africa, or just simply Dutch civil law for other parts of the world. And then they imposed it on Indonesia. So that's how I know that this legal history shows us how effective legal harmonization can work if we are conscious of legal history. I thank you.
Okay, thank you very much, Prof. Anthony, for highlighting the Global South perspective and for showing how the harmonization of customary, religious, and state law can become a powerful path toward justice, inclusivity, and legal innovation. Prof. Anthony Sidiala highlight about political pluralism in Global South as a colonial legacy that creates tension between state customary and religious laws. He emphasized the need to harmonize legal system by integrating indigenous values to make modern law more adaptive and socially inclusive. Ladies and gentlemen, with this final keynote, we have now journeyed through the first perspective from Indonesia, and then Malaysia, Netherlands, and South Africa, each offering critical reflection on how legal pluralism shape our societies. Together, our speakers have reminded us that legal pluralism is not merely about multiple systems coexisting, but how dialogue, adaptation, and mutual respect can transform law into an instrument of equity and social progress. Ladies and gentlemen, we will now open the floor for our final Q&A session, inviting your question and reflection of our brief comment. If you have question, please raise your hand. You also can use the reaction features in your device in Zoom or write in the chat box. Please introduce yourself before you give the question. Any question? Okay.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Iqbal. I'm from Faculty of Law, University of MICoLLS. Does legal pluralism in post-colonial countries truly reflect the diversity of legal system, or does it instead reinforce the inequality between Western law and indigenous law? Apakah pluralisme hukum di negara-negara bekas jajahan benar-benar mencerminkan keberagaman hukum atau justru memperkuat ketimpangan antara hukum barat dan hukum lokal? Ini Ibu translate.
Is it clear that question, Prof. Anthony?
Yes, it's very clear. So I wanted to know if you were going to take a group of questions together or maybe one each, so I can answer straight away.
Okay, maybe we can add we have another question. After that, you can answer. Okay, please, the second question.
Thank you for the time. My name is Hadi Subaja, and I'm from Faculty of Law, University MICoLLS. In here, I just want to ask a simple question. If the foundational value of indigenous law, such as communality and spirituality, must be reinterpreted to fit modern constitutional and human right framework, is harmonization truly a dialogue between legal system, or is it sophisticated continuation of colonial domination under the guise of legal modernity? Thank you, sir.
Okay, we already have two questions, Prof. I would like to invite you to respond that question. Thank you.
Thank you very much for the
Oh,
questions.
I'm sorry, Prof. Anthony, we have one more question. Yeah, is it okay, Prof? Okay, thank you.
Thank you, moderator, and hello, Mr. Anthony Adiala. Let me introduce myself. My name's Nanda Setia Saputra. I'm from Faculty of Law, MICoLLS University. This is simple question. So my question is, what role do younger generation play in pressing local wisdom while adapting to global legal development? Okay, thank you for me. Assalamualaikum warahmatullahi wabarakatuh.
All right, so we take these three questions and then maybe we can then take more questions if need be.
Okay, yeah, you can answer the question, Prof.
So the first, thank you very much for all the questions. The first one wants to know whether legal pluralism reflects diversity or whether it reinforces the tensions between legal orders caused by the colonialism and its legacies. So there is no easy way of answering this question except to say that currently, the way policymakers in the Global South handle legal pluralism is from a conflict of laws perspective. So they reinforce tensions between the legal orders. By legal orders, we mean the adult laws and the statutory laws. And I'll tell you why they do this. The reason why this tension exists, or this conflict of laws approach is taken, is because the apex judges and the top legislators, the parliamentarians who handle the policymakers, so to speak, they have been trained in the Western legal tradition, many of them. So in a way, they are the elites. They are the people who stepped into the shoes of the departed colonial masters. And so most of them behave exactly like their masters, sometimes unconsciously without knowing it. And unfortunately, academics also take this conflict of laws perspective. So instead of looking at the conversations taking place, the dialogue occurring between legal orders, they look at the tensions between them. So then we can say that legal pluralism in the Global South is not deep, it is shallow or state or weak. So legal pluralism is weak legal pluralism because they impose laws, and the colonial statutory laws, they dominate. And by dominating, they cause tension. So if more respect is paid to cultural diversity, to the voices of local communities, traditional communities, to local wisdom, then we will not have this tension. So I hope that answers the question. Then the second question is if legal pluralism is a continuation or if it's a break from the past. Yeah, this question is related to the first one. So the type of legal pluralism that we have in the Global South is more like a perpetuation of coloniality. So it sustains the colonial conditions, those institutional structures put in place by colonialism. And in a way, it's inevitable, it's unavoidable. Because if you look at your Faculty of Law and you check the content of your curriculum, you would find that there is very little indigenous content, that most of it come from what? European knowledge hegemony, European knowledge systems. Even the design of the buildings, everything apart from the native languages come from or influence of colonialism. So yeah, in a way, legal pluralism is a perpetuation, is a continuation of that colonial legacy, that coloniality. And then finally, the last question that seems to flow from the previous two, what can the younger generation do? What role can they play in promoting local wisdom? Well, I always say this, that I joined academia. I entered the university to teach, just to bring up a new generation of scholars who will be aware of their legal identity, aware of their new cultural identity, and then do something about it. So it's not just enough to write academic papers that no one reads, unless maybe you're writing in popular forums like The Conversation, then people from all over the world will be interested and then they would read. It's not enough. We need to bring up a whole new generation of scholars who will go out and enlighten people about what happened to their indigenous laws. Because something tragic happened to the indigenous laws of the people of the Global South. Many of them do not know it, but there was a systematic erasure of local wisdom and their replacement by European laws, European knowledge systems. So we need a new generation to spread this awareness. And the challenge is up to you young people over there and to us to bring up that new generation. Thank you.
Okay, thank you very much, Prof. Anthony, for your insightful and thought-provoking response and for sharing such valuable perspective with us, especially about the legal pluralism in Global South. By the way, thank you once again, Prof. Anthony, for being with us today in the FIT MICoLLS 2025. It has been an honor to have you at this conference. We wish you all the best and look forward to further future collaboration with us, maybe, Prof. Okay. Ladies and gentlemen, as we come to the close of this remarkable panel, the fifth MICoLLS 2025, allow me to express my deepest gratitude. Today's session has shown us that legal pluralism is not merely about the coexistence of legal system, but also about dialogue, negotiation, and pursuit of justice that respect cultural identity and social change. From tension between religious protection and freedom to the instruction of Sharia and civil law to the global local dynamic of plural governance. And finally, to the harmonization challenge in Global South, we have the witness how local wisdom and global perspective meet in the search for inclusive law. On behalf of the organizing committee, I would like to sincerely thank you to our keynote speakers for their profound contribution and all participants for your active engagement and thoughtful reflection. It has been my great honor to serve as your moderator. Thank you very much, and we look forward to see you in the next session of the 5th MICoLLS International Conference of Legal Studies and Social Science in 2025. The session is now concluded. Okay, thank you, Prof. Anthony.
Thank you very much. My pleasure.
Untuk peserta di dalam grup partisipan, tolong diisi absensinya. This is the end of our conference for today. You can leave the room. So all participants, see you in the second day tomorrow at the panel session. Oke, Assalamualaikum warahmatullahi wabarakatuh.